we go. Okay. So I've got everybody's case briefs, but as you know from the email that I sent earlier this afternoon, I haven't had a chance to grade them all. I had a very busy week last week and a pretty busy weekend. And I'm trying to be as detailed as possible in the comments that I'm giving you on your case briefs, because I really want it to, I'm hoping that the feedback I give you will enable you to write better case briefs as we go forward. Not that they've been bad, but there's always room for improvement. First, I want to take roll real fast. Mustafa, are you here?
I'm here.
Okay, and you're the one that, do you need to leave early for tennis?
Practice, but I'm fine.
So you're good to go?
Yeah.
Okay, so Mustafa's here. Kyle here? No Kyle. Sarah?
Here.
Okay. Turner, right here. Lucas?
Yeah.
Okay. Mary's not here. Daniel?
Yeah.
Pim?
Yes.
Do you go by Pim or one of your other names?
That's my full name.
Okay. Alicia? Yeah, Alicia?
No,
No. No, Alicia? Yes, is that Alicia?
Yes.
No? Okay. Christina?
Yeah.
Okay. Gabriel, you're here. And Ty, you're here.
Yeah.
So your name's pronounced Tylen.
Tylen.
Okay, even though I said Thalen last time. Don, you're here. Ksenia?
Yep.
Okay. Emmanuel?
Yep.
Austin, you're here. Anaclete? Am I saying that right? Okay. Courtney, you're here. And Gordon?
Yeah, yeah.
Okay. So yeah, we're just missing two. All right. So first I want to talk about case briefs. Mainly, and again, I've not graded everybody's yet, so I don't know if this is an issue that many of you have encountered or mistakes that many of you have made. But first of all, as far as citations go, just so we're clear, the first cite, you're going to do the full name of the case, the full style. So with the first case brief, it'd be Maine Community Health Options versus United States, italicized, and then comma, 590 US, the underscore, and then 2020 in parentheses. Go after you make the first cite, you then shorten your cite down. And so you could just say Maine Community Health. There's not one right way to do it, but you can make that style of the case, that's the name of the case, shorter. It's probably better with that kind of case, rather than saying just Maine, to say Maine Community Health. I'll still know what you're talking about, but the main point there is you don't want it to sound like it's a state that was the party, because it was actually a health insurance agency, not a state that was the party to the case. So you do Maine Community Health, comma, 590 US at page number, and then you cite to whatever page number you're citing. Now we talked about last week, don't cite to the syllabus of the case, which is the first 4 to 5 pages that gives you a brief, kind of a condensed overview of what the opinion is about. Those are very useful. You certainly should read them because it kind of lets you know where the case is going to go, but you should not be citing to them in your case brief. Now, I did notice that on one case brief, and I imagine I'll probably see it on a couple of others, the page numbers. Courtney, if you go to the Internet Explorer there, I didn't make it clear to you all exactly which website. Just scroll down, please. It's, when you go into Google and type in the name of the case, it should be supremecourt.gov, the PDF, and it'll say Supreme Court of the United States. If you'll click on that, please, Courtney. That's the version or the published version of the case you should be citing to. Some of them will have the page numbers run together, or it'll be a PDF and you'll see like there, it says 1 of 43. Don't be citing to that page number, cite to this page number. So if, Courtney, if you'll scroll down, please. This is the syllabus. Don't cite to the syllabus. Let me keep going, keep going. There, see how the pages start over? That's the page numbers you want to be citing to. And it does the same for the dissenting opinion and if there's a concurring opinion. Now, some of the sections, one of the sections will say the reasoning of the concurrence. If there's not a concurring opinion, which was the case with the main opinion, You don't need to say reasoning of concurrence because there is no concurrence. But you do need to talk about the dissenting opinion. There's always going to be a dissenting opinion in all the cases that we're looking at. When you're citing, Courtney, if you go to the whiteboard, please. When you're citing to the dissenting opinion, so with the main case, it would be main community health, and then you do, and that's italicized, 590 US at 2, or whatever the page is, and then in parentheses, you'd say, in this case, it was Justice Alito that filed the dissenting opinion, and you put dissenting. So that's how you need to be citing to the dissenting opinion. It's just a little bit different. Again, the page numbers are going to start over, and then you need to be sure to put that parenthetical. And sometimes you get more than one dissenting opinion. So if you're citing to Alito's, that's why it's important you put one that I know you're citing to a dissenting opinion. And if there's more than one, I know which one you're citing to, because the page numbers will reference that. So as far as citations go, that's how you need to be doing it. I'm not going to be too harsh on the first case brief, since we didn't really talk about, proper citation formats in depth. But going forward with the second and third case briefs, you need to make sure that you're citing them correctly. And Mary? All right. We're talking about proper citation formats for the case briefs. So again, for dissenting opinions, make sure you got that parenthetical, the justice, his name or her name, comma, J, comma, dissenting. And it's the same if there is a concurring opinion. It'd be the same thing, except instead of dissenting, you would put concurring. And then again, as far as which versions of the case you go to, make sure you're getting the one that's published on supremecourt.gov, not from any other website, law.cornell.edu. It's a good website, but just use supremecourt.gov. And some of you did cite to some other publications, I guess, news articles, things like that, talking about the cases. Those are useful for understanding the cases. These Supreme Court cases are not easy reading by any means, and they're often not exciting reads either. So it is good to consult other works to kind of help you understand the case, but don't be citing to other publications. You only need to cite to the Supreme Court case itself. But on that note, do not try to take someone else's work and pass it off as your own and just not include it and say, well, he only wants me to cite to the Supreme Court case, so he'll never know the difference. I probably will. I can check those things. So you can use them to help you understand it, but don't rely on them for actually writing your case brief. You can use them to help you understand what the court is saying, how the court is ruling. But when you write the case brief, you should only cite to the Supreme Court opinion and only be looking at the Supreme Court opinion when you're actually writing the case brief. Does that make sense to everybody? Does anybody have any questions about that?
Yeah, a couple questions.
Yeah.
So if there's no concurring opinion, do you still put a concurring opinion header and say there wasn't one? You just totally omit
No,
that?
you can just omit, if there's no concurring opinion, you can omit that section, just have the reasoning of the majority, or and you don't have to say that exactly, you can say majority opinions, reasoning, just as long as it's clear in the header that you're talking about the majority opinion and then reasoning of the dissent. And again, if there are multiple dissents, which often happens, you can do it all in the one section, reasoning of the dissent. Just make sure that you're clear. If it's Alito's dissent, you cite to that one. If Thomas is dissenting, those two are the ones that dissent the most.
Break those up, like an Alito section and a Thomas section?
You can, if their dissents have, you can do it either way, whatever makes more sense to you. Just as long, again, as it's clear who you're referencing when you say, now Alito and his dissent disagreed for these reasons. In contrast, Thomas dissented and said this. But again, just make sure your citations are clear, which dissent you are citing to or referring to. Another big point, as far as paraphrasing and quoting directly, you can quote directly sometimes. It's okay to do it occasionally, but you have to put it in quotation marks. However, you can't just regurgitate exactly what the Supreme Court said and cite to it. Now, you include the page cites, and that's fine, and you cited to the correct page. But if you're just regurgitating exactly what the Supreme Court wrote down in their opinion, then it's not showing me that you understand the court's opinion. It's just showing me that you read it enough to copy it down in Word, and that's not good enough. You know, I need you to show me that you have digested the opinion, you understand it, and you're undertaking your own analysis of it. Now, I don't expect your analyses to be perfect. There are plenty of lawyers that don't know how to analyze a Supreme Court case, and it's tough. Like this is hard stuff, you know. And I understand that, and I appreciate that. So I'm not going to expect you all to be, you know, able to draft an appellate brief to file with the Supreme Court by the end of this class. But I do expect you to be able to read a Supreme Court opinion, understand the reasonings behind it, the arguments that the justices are putting forward, and to be able to show that to me in your case briefs. And on that note, you know, today we're going to be talking about a lot about diversity in the workplace and equal protection and, you know, 14th Amendment and all that good stuff. So we'll kind of just get a preview. Now, I'm assuming all of you have started working on your second case briefs. Yes, which is good. You should be. So the Bostock versus Clayton County case, have all of you all read it yet, or at least reviewed it? All right. What does anybody have any thoughts on the Supreme Court's ruling? Anybody want to talk about it generally? What's that case about? Okay. Discriminating against sex in what way? You're up first.
The discriminating against sex, and they're trying to figure out what the word sex means. Is it talking about sexual orientation or the biological sex of the man?
Okay. And is there, so sexual orientation, is there any other areas it's talking about? Yeah? Transgender. Okay. So what did the majority rule? Yeah, with the plaintiff? So they ruled that, and specifically, what would that mean?
The employer that fired the Bostock for being gay or participating in a softball, I forgot the.
It's like a gay softball league.
Yeah.
I didn't know they had those things, but all kinds of softball leagues.
So he got fired for that. I guess the Supreme Court or the majority, they ruled with the plaintiff, which is Bostock, suing the company for firing him because he participated in that. Because he was gay.
Now, the lawsuit was against not a company. Well, I guess sometimes some of them were. There were multiple parties, right? But it was against a county. And there's particular, you know, when the government's involved, when you're talking about discrimination, there's actually, it's arguably there's a higher standard that applies for governmental entities. Employers have a little bit more leeway, not much, but they do have a little bit more leeway when it comes to, you know, the application of Title VII. So that's kind of a preview of what we're going to talk about today. So the case brief's going to kind of blend in nicely with that, or the case that you all are writing your briefs on.
I have a question.
Yeah.
So in this case, there are three parties, three plaintiffs.
Yeah.
How does the Supreme Court case get referenced as Bostock and not the other two? Is it a chronological deal, or is it, how is it?
They'll often do it in just, you know, I don't know if there's a set way that they do it.
And
you
no
know,
one is any more important than the other. They're all three.
Yeah.
Considered together.
Yeah. They essentially.
Just like Maine Community Health.
Yeah, exactly. There was several different insurance companies were involved. There was, I think, 3 different insurance companies in that case. So obviously they're taking plaintiffs that are all similarly situated. And that's often the Supreme Court will take a case. Well, they'll see in multiple different circuits. They might have different circuits. Really, there are 11. Is it 11? I think there are 11 federal circuit courts that cover multiple states. Like we're in the Sixth Circuit, that's Tennessee, Kentucky, Ohio, and Michigan. How much do those states have in common? Probably not a lot, but I guess they just didn't want to do South and North. They wanted to kind of split it up a little bit. But so they'll look at different circuits will rule in different ways. So like Sixth Circuit's a fairly conservative circuit. The Ninth Circuit, that's California, Washington, Oregon, Hawaii, and Alaska, is really liberal, right? So they'll rule in different ways. And that's often how the Supreme Court ends up getting these cases, is they say, okay, we've got a conflict between how the Ninth Circuit is ruled on this issue versus, say, the Sixth Circuit. But again, to your question as to how they decide whose name gets to go first, I don't know that they have a set formula for doing it. It's not something that I've sat down and like really researched, but I would imagine it'll often be, who filed first, or, alphabetical order. That's probably, I don't think there's even necessarily a set formula.
It is common that you reference one name, you're
Yeah.
not necessarily including all of them.
Yeah, and to that point for the case briefs, like you don't need to put, Bostock, comma, I can't remember what his first name is, and then all three plaintiffs versus, all the different defendants. You can just say the kind of how the main reference, party reference, and they do that primarily just for it's a lot easier to say one party versus another party than to say every single one of them all crammed together. You'd have a paragraph that's just the name of the case. So maybe you should do that. No, but now everybody read the discussion post for week 4. Is that Washington Post article? Yes. Who can tell me what the Washington Post article was about?
It was discriminating like men and their parental leave.
Yes. And who was discriminating in that case? Mhm. What kind of employer was it? Anybody? Yeah, it was a law firm. Jones Day, or like a worldwide law firm. The guy was making $500,000 a year. Lawyers don't make that in Knoxville at all, not even close. It's like 500. That really jumped out to me. I don't even remember the rest of the article. 500 grand? What? So I'm moving to DC, guys. No, I'm just kidding. It's not worth it. That would not, $1 million wouldn't be worth it. But so he had said he sent an email, right, to his supervisor, the managing partner for his department. And he's this superstar appellate attorney. So he's the kind of guy that's going to be writing the briefs to the Supreme Court for, the cases you're writing these case briefs on. And he sent an email to him, and his wife had just had a child. And he said, basically, hey, well, first off, what was the company's policy? What was that law firm's policy with respect to parental leave? Mm-hmm. Yeah. So the women got 18 weeks total of paid leave. And then there was an additional 6 weeks of unpaid leave that they could get. And the men, I think it was the men could get 10 weeks of paid leave and then 6 weeks unpaid. And he basically wrote him a little email and said, I want the other 8 weeks unpaid leave or else. And they didn't like that. And they said, well, or else, yeah, you're fired, right? So they fired him. And then he filed a lawsuit alleging what? Under, and Title VII, that's the big one we're going to be talking about today, right? So Title VII is part of the Civil Rights Act of 1964, I think it is. And Title VII, what does Title VII state? What's the basic premise of Title VII?
Like, you cannot discriminate against an individual based on their race, sex, culture, color, national orientation.
And religion. That's right, and religion. So you can't discriminate based on race, color, sex, religion, or national origin. And that's really and that is based on the 14th Amendment, which was passed. Does anybody know when the 14th Amendment was passed or ratified, I should say? Now, the 14th Amendment, 18 something. 1866, just after a certain event in American history, right? And so it was there were 3 amendments passed to the Constitution in the aftermath of the Civil War. And the 14th Amendment has had the widest impact. I mean, you could say the 13th Amendment had the widest impact, but in terms of, had the most immediate impact. But the 14th Amendment, in terms of, it is still shaping American law. And the 14th Amendment, what does the 14th Amendment say?
You have citizenship, where you're born.
It says that, but it does say, it starts out, no citizen or person, naturalized or born in the United States shall be denied what?
Freedom. Freedom.
Freedom? Well, what's a different way of saying that? No, 13th Amendment is, that's abolishing slavery, right? And involuntary servitude, except for punishment as crimes. I think they add that proviso in there. But the 14th Amendment is no state shall deny its citizens equal protection under the law. And so the 14th Amendment directly applies to the states and says you can't discriminate against people, or no, not that you can't discriminate against people, that's Title VII. 14th Amendment is saying everyone has to be treated equally under the law. You can't discriminate in the application of the law to any citizen of the states, and the state can't do it. Now, how effective was that? Well, the fact that they had to pass the Civil Rights Act almost 100 years later tells you that they didn't have a whole lot of luck implementing the 14th Amendment. But so going back to the Washington Post article, Jones Day, the big law firm, $500,000 a year salaries. I still can't. That's like all I can think about when and the wife was making $525,000. It's crazy. But so they fired him and they filed the lawsuit alleging violation of Title VII and that men were being treated unequally. Now, did anybody catch what they allege in the complaint that one of the partners said to the male plaintiff when he said, I need to have just as much leave as, I'm entitled to just as much leave as a woman is for parental leave? Yeah, he said, what are you going to do with that parental leave? Watch your wife unload the dishwasher? I bet he thought that was hilarious. Now it's not so funny, is it? So what is the status of that case? Did anybody look to see what's happening to that case? Anybody know? Same thing that happened to most of my cases, coronavirus. It's just kick the can down the road. They're not even close to trial. But that's the wheels of justice turn slowly. And that case was filed, I think, in 2019. And yeah, here we are, 2021, and they haven't made a whole lot of progress. And it'll probably end up settling. That's how most cases go these days. And actually, it was one of you commented on the discussion post, I can't remember who it was, but made some excellent points, particularly at the end, that you'd think this giant law firm that's like one of the biggest law firms in the world would be better at negotiating, but apparently not. So the Equal Protection Clause, we know what it is. The no state or states cannot treat people differently when in their application of the laws. There's equal protection to all citizens and all people born here naturally or naturalized here. Now we're going to get in later in the class into the issue of undocumented immigrants, illegal aliens, however you want to refer to it, but people who have entered the country, without or in violation of the immigration laws. But we'll talk about that here in a little bit. And we know that the Equal Protection Clause is found in the 14th Amendment, right? It's the first and most important of the 5 different clauses in the 14th Amendment. Now, does the 14th Amendment apply, the Equal Protection Clause, does it apply only to the federal government? Yes or no? No? What does it apply to? I'm sorry?
Doesn't apply to every,
It applies to state and local governments, right? So 14th Amendment applies to state and local governments. Well, what about the federal government? Does that mean the federal government can be unequal in its application of laws? No. Why not?
Isn't there a law that says, something like, what's written, those will can't bring some extra information to try to tell me what you think this means?
No. It's in the Constitution, but it's not in the 14th Amendment. The 14th Amendment does apply to the federal government, but not directly on its face. Directly on its face, the 14th Amendment applies to state and local government. It says no state shall deny any citizen or person born or naturalized in the United States equal protection of the laws. How does that clause apply to the federal government? I'll give you a hint. It's through another amendment to the Constitution. Can you all tell me which one? Not the first one. Due process. Ringing any bells? Close. It's the Fifth Amendment, due process clause of the Fifth Amendment, which is often tied in with the Fourth Amendment, which is, the big thing with the Fourth Amendment is you're protected from, searches and seizures of your property without a warrant issued upon probable cause, right? So the 14th Amendment applies directly to state and local governments, and it applies to the federal government through the due process clause of the Fifth Amendment. So that means that ultimately, the bottom line is both federal, state, and local governments have to apply the law equally to all people. Except maybe what about illegal undocumented immigrants? We'll talk about that here a little later. Now, in interpreting, or in applying the 14th Amendment, the Equal Protection Clause, whether at the state and local level just through the 14th Amendment, or at the federal level through the Due Process Clause of the Fifth Amendment, there are two main levels of scrutiny that courts will apply. Now, is it down here? Okay. There are two levels of scrutiny. Well, there's several right now, but two primary levels of scrutiny that courts will apply when looking at whether a law violates the 14th Amendment. What are those levels of scrutiny? Strict scrutiny. Now, what is strict scrutiny?
Narrow interpretation.
Yeah. Well, not narrow interpretation, but in terms of how they look at the law, it is narrowly tailored. Yeah, narrowly tailored. I should say, law must be narrowly tailored to what?
State interest.
Sir, yeah, what kind of state interest? There you go. Yes, compelling. I didn't have to do that underline. I don't know why I did. Compelling. Can you all read this? My handwriting's not any better if it was a normal board, but so strict scrutiny, the law must be narrowly tailored to serve a compelling state interest, or government interest, you could say. When you say state, you're essentially saying government, right? But I just want to make it clear that we're not saying state interest. That doesn't mean only Tennessee or Arkansas or all those other states. That's a government. So we'll stay government there just so it's So narrowly tailored to serve a compelling government interest. Now, when does strict scrutiny come into play? When is a court going to apply strict scrutiny to a law that a plaintiff has alleged violates the 14th Amendment?
Done it in cases where race or ethnicity are involved.
Yeah, race, ethnicity, what they call a suspect. Well, shoot, now I can't remember. It's like suspect class, like a suspect classification, right? So applies where law implicates. Now, what do we mean by suspect classification? Exactly. Yeah. So that's going to be basically where there's like an immutable characteristics that applies to a whole group of people who are kind of unique. And again, it's like you said, that's race, that's ethnicity, national origin, religion, and now we're seeing that law is expanding. Now that includes sexual orientation, and that's not just what your sexual preferences are in terms of, I guess, who you're attracted to, but also in terms of how you identify your own sexual identity, right? So what is the opposite? So that's one end. You got strict scrutiny. What's the other end?
They term intermediate scrutiny.
Now there is intermediate scrutiny. That's as the name indicates, it's right in the middle, right? So that what's the least, I guess, the least restrictive analysis that courts apply? Rational basis, right? And so that's where you don't have one of those suspect classifications. Oops. Rational. So what is rational basis review? What is that? What's the kind of the basic definition of rational basis review? Yeah. Now they're all tied to a government interest, right? Strict scrutiny has to be, you've got to have it narrowly tailored to serve a compelling government interest. So it has to be an interest that is, and maybe we should step back and kind of talk about that. What would be an example of a compelling government interest?
Racial diversity at college, state university.
Yeah, that's the University of Texas case you're talking about there. You've got that. What about, in the wake of September 11, 2001, right? They're going to say, we have to protect our people from these terrorist attacks. We've had this massive terrorist attack. The state has a compelling interest. There's a compelling government interest in keeping our people safe from further terrorist attacks. So they will pass laws that, might say, people of the Muslim faith can't immigrate into the United States after, January 1, 2002. The government says that's going to get strict scrutiny is going to be applied to that. Why? Because you have a law that is targeted towards a specific group of people based on their religion, right? So any court that looks at that law to determine whether it's constitutional is going to say, is this law narrowly tailored to serve the government's compelling interest in keeping the people safe? Now, with strict scrutiny, I'll tell you, if strict scrutiny is applied to a law, it is 9 times out of 10 going to get overturned. It's going to be held to be unconstitutional. That is a very strict scrutiny, like it sounds, is a very tough hurdle to overcome. And there's got to be, in addition to this, that it's narrowly tailored to serve a compelling government interest, they also have to show that there is no less restrictive alternative, that this is the only option we have with this law to serve this compelling state interest. There's no way we could do this that is less restrictive to this group of people or this class of people. Does that make sense? Okay, so that's one end of the spectrum. The other end is rational basis review. And that's where they're going to find, okay, this law doesn't really seem to implicate a suspect classification. There's not a specific group that it seems to be targeted here. So they're just going to look at, is this law reasonably related to a legitimate government interest? That's an S, my gosh. Reasonably. Right? So if a law is being analyzed or reviewed under the rational basis review, probably 8 times out of 10, maybe 9 times out of 10, it's going to survive. It's going to be upheld, and they're going to say this does not violate the 14th Amendment or the 14th Amendment as applied through the Due Process Clause of the 5th Amendment in cases of federal laws. We do have intermediate scrutiny. And that intermediate scrutiny is, like it sounds, it's in between the two. That's substantially related to accomplishing an important government interest. So you've got strict scrutiny as a compelling government interest, intermediate scrutiny is an important government interest, and then rational basis is just a legitimate government interest. So it can't just be, not related to anything the government's actually doing. If it's a law that says, senators can make more money than off stock trades than normal people, that's not a legitimate government interest, right? That wouldn't even survive rational basis review. But that's the lowest hurdle, legitimate government interest. And that's pretty broad, right? Compelling government interest is it's got to be, hey, this is really, really important, right? So, and with rational basis, and there's also, with strict scrutiny, it's not just, there's suspect classification, there's also if it involves fundamental rights. So it's not simply, if it's that implicates that Title VII grouping of race, color, sexual, sex, religion, and national origin. It also includes fundamental rights. So that could be if it's a law that restricts people's First Amendment rights. Going back to our last class, we talked about the ag-gag laws, right? That's one. Okay, this implicates the First Amendment and people's ability to say what they want, without government interference. We're going to give that strict scrutiny, and it better be a really compelling reason that they're doing this in violation or in apparent violation of the First Amendment. And again, that's why you see that strict scrutiny, laws that get strict scrutiny applied to them are almost always going to get overturned. So, how about the Diane Schroer case versus James Billington? The one in the book. That's the one that was, well, why don't you all tell me, what did that case involve?
One who was like a colonel or something in the military. Interviewed for a job, he's going to go inform Congress and speak to hiring officials. They're about to make him a job offer, and then he had a meeting with her and said, "Go start living as a woman." Yeah.
So, and it was actually a job that had to do with terrorism, right? There was like tracking terrorists or investigating potential terrorists. Now, right before that, the book talked about that case, they had a quotation from a Judge Barquette. And y'all need to take notes on this. Just kind of want to note this. A person is defined as transgendered precisely because of the perception that his or her behavior transgresses gender stereotypes. Do you all think that's right? Do you think he's correct? That transgender, they say transgender because it transgresses societal norms with respect to gender? Or does transgender mean like if you have a transoceanic voyage, you were crossing the ocean, right? Or transvestite, you are wearing clothes of the opposite. You know, I don't think that judge is correct there. I don't know why they put that in there, and you'll see this in this book. This book has a very particular political slant to it. You know, first year I taught this course, the first chapter where we're talking about all the different, you know, deontology and utilitarianism. I'm like, this book is great. Then I get to this stuff and I'm like, this book is a little bit too political for me. And I'm not saying, you know, that that's one side of the political aisle is correct and the other isn't. It's just in the context of this, you know, I don't like books that go one way or the other. If it was the opposite direction, I'd have just as much a problem with it. But so I'm not really sure why they put that in there. I don't think that judge was correct. I don't think it's referred to as transgender because it transgresses societal norms or perceived gender stereotypes. So I just wanted to point that out. You'll kind of see that in the book. It'll occasionally, they definitely have a particular message that they're trying to get across. So, and that's fine. If you agree with that, that's fine. If you disagree with that, that's fine too. But just kind of be aware of that. And it's not just in this textbook. You know, everybody's kind of got their own message to send. That doesn't mean, just because it's a textbook doesn't mean it's right all the time. But anyway, so back to the Schroer versus Billington case. Austin, you as you correctly stated, when he applied, or when the plaintiff applied, was as a male, right? And he had served for 25, 35 years, something like that, and had a distinguished record, was far and away the best applicant that they had. And then at the end of they tell the plaintiff, okay, you are, you know, you're in the top list of our top candidates. You know, we've narrowed it down to you and a couple other people, and we think you're great. He says, okay, well, I want to have lunch with you, right? With one of the, I guess the main person who's going to make the decision. And like you were saying, he says, I'm going to live as a woman. You know, I'm not a man. I want to let you know now. I don't want to transition, you know, after I start the job. I think it'll just make it easier. And the guy said, well, you've really given me a lot to think about here. You know, they started out saying, God, you're great. Everything about you is great. You're just the best applicant. It's like, I'm going to live as a woman. Oh, maybe you're not. Let me think about that. And the next day he says, well, we're going to go with somebody else because gave some what the courts call pretextual reasons. But it wasn't until he said, I'm going to transition and he becomes she. And they're like, well, we're going to go with somebody else. He's not as good, but we're going to go with him, right? So do you all agree? And the judge, how did the court rule in that case? Was Title VII violated? Did they discriminate against the plaintiff on the basis of sex? Yeah, yes. Now the judge made the comparison, you know, if they were hired or they applied and they were Christian, and then they converted to another religion, converted to Judaism right before they started. And they said, you know what, actually, we're going to go in a different direction. Is that a fair comparison, you all think, or a fair analogy?
I think it's fair in the sense that like the protections of religion and I guess gender in this case are the same protections. They have to be subject to the same kind of scrutiny. Like
Yeah. And I think that's right. In terms of the legal analysis, we could sit here and argue, well, no, religion and gender, you know, they're two separate things. But you're correct in terms of the legal analysis. It is the same. It is. There are differences between them in terms of practical. You know, religion is not the same thing as gender, but in terms of how the law applies, that's how Title VII is written. It is, you treat it the same way. It's going to get that strict scrutiny. And in this case, they found, hey, this violates Title VII, therefore it violates the 14th Amendment. And but how did the court? I don't remember. How did the court? What ultimately happened there? Did they make them Did he get the job, or does the book tell us if they give him the job or just gave him money damages? Probably money damages. Yeah, I don't think they do. The book is always like, research this, research that. And I'm like, let me finish the chapter first. So I don't know how if anyone wants to look that up and let us know, feel free. But so the court talks about pretextual reasons, or they ask us about, the book asks us, what do courts mean when they say pretextual reasons for someone being fired? What does that mean? Anybody?
Just sort of like they were given reasons, but not the real reasons.
Yeah, essentially. What they're saying there is, it's, we didn't go with her because, she didn't get along with people as well or something. You're just throwing something in there to be like, no, it wasn't because she's transgender. No, not at all. It's because she didn't get along with people or something. You're basically just a flimsy excuse to try to hide the fact that you are firing someone for one of those protected, that's one of those protected reasons because of, in this case, the person's gender, or because, the analogy you gave of he converted to Judaism, and you're like, oh, well, it was because he, again, can't think of a good example right now, but you all get what pretextual means, and that's not acceptable. You can't just cover it up when the real reason or one of the reasons. That's another thing. Courts don't care. It doesn't have to be that the only reason you fired this person was because of their race or their color or their sex or their national origin. It can be just one of the reasons, and that's not acceptable. You can't do that. Now, for your all's purposes, we all aren't going to be, I assume, aren't going to be lawyers. I don't recommend it. But you all are out in the real world, quote, and you're in charge of hiring people. You're running your own business, or y'all are getting MBAs, so you're probably going to be in a supervisory sort of position in some, whether you own the business or you're a manager. What does this tell you all in terms of the hiring and firing decisions that you make?
Pretty solid ground.
Yeah, you better not fire anybody because they're black, or because they're gay, or because they're transgender, right? And that's the purpose of the law, is we want to look at people for their merits, essentially. Now, they don't say that, but that is really what you're doing, is you're saying, okay, there are these immutable characteristics, or these characteristics that we're going to allow people to have, and you can't make any sort of hiring or firing decisions based on those characteristics. You can say if they're a crappy worker and they don't show up on time, fire them all you want. Tennessee's an at-will employment state. We're going to talk about that next week quite a bit. But, you at will in a state like Tennessee, that means you can fire them for just about anything except the stuff protected under Title VII and the 14th Amendment, right? So that's the real world application here. I know this is kind of law and ethics, and it seems sort of academic, like how does this actually apply to the real world? Well, that's one of the ways it does. Can be significant consequences for you if it's your own business, or for your employer if you make a decision, you make a decision in part based on something that would be in violation of Title VII. So, and that's what we see with the Bose case, right? That we're going to write, that you all are writing the case briefs on. The second case briefs is, and it's really an expansion, which is, it's when they drafted Title VII, things like homosexuality and transgender, that was not nearly as, and I'm saying it didn't exist by any means, but it was not nearly as common or as socially accepted as it is now. So it's interesting, you see how courts can sort of expand or contract the application of laws that already exist to kind of fit the evolutions in society. And I think we saw that last week when we were talking about data privacy and stuff, where they have to fit a square peg into a round hole when it came to the Stored Communications Act, right? that, hey, they should update the laws, to take into account the invention of the internet, but we're going to make it work with what we got. So they take this law from 1964 that when they passed it, I guarantee you that 98 out of 100 senators that, if I don't know if it passed unanimously or not, but I can guarantee you they weren't thinking, and this is going to protect people for homosexuals and transgender people. They weren't. I guarantee you they weren't thinking that. But how we perceive what sex means, that can change, and the courts can take that into account to try to broaden the protections that the law gives to people. How about y'all remember the Target bathroom in North Carolina passed that law that said, people, their gender assigned to them at birth or the sex assigned to them at birth, they can only use that bathroom. There was a big debate, right, over people who say, well, I was born a man, but identify as a woman, and I'm going to use the woman's restroom. And people in North Carolina, they're very conservative, sort of like Tennessee, and they said, no, you're not going to use that bathroom, you perverts. And they're just taking this extreme view of it, right? And Target says, oh yeah, well, you can use whatever bathroom you want. We don't care. Looking at this in terms of ethics, so this class is law and ethics, right? We've talked a lot about the law today. In terms of ethics, which is the more ethical approach in the context of that specific example? The Target says use whatever bathroom you want. North Carolina General Assembly or their legislature, whatever they call it, says you have to use the bathroom that, the gender you were assigned at birth is the bathroom you have to use. From an ethical standpoint, which do you all think is the more ethical approach? And let's start with the utilitarian approach.
I feel like from an ethical standpoint that they should use the bathroom that they feel right to use.
Okay. And now does that, under the utilitarian approach here, because remember, we've got the three main ethical approaches to the law, right? So the utilitarian, and that says, what is the greater good, right? And so we can harm a few as long as it's for the greater good. So do you think under the utilitarian, is it for you say North Carolina, Mary, do you still say Target? And with this, there's not really a right answer in terms of the ethical. I mean, there can be, but in this case, there's not really. It's kind of how you interpret what is for the greater good, what is the greater good, right?
That's where I have a hard time distinguishing, because I can tell you what I think North Carolina or Target answer.
Yeah.
But the ethical, utilitarian, or
Deontological.
Yeah. Still a hard time.
Yeah, and that's, unless you get real deep into Kantian philosophy, which I have not done, and I don't expect you all to do, but, deontology, you're welcome. That's my pleasure. But deontology, right, that's the absolute principles, universal principles, right? There's an absolute truth. That's the one where the person trying to hide from the murderer, don't tell this guy I'm hiding here, he's going to kill me. I cannot tell a lie, he's right there. That's deontology, right? So, and that does raise a good question. To your point, what is a universal principle? Is it that the universal principle is we can all do, decide what our gender is? Or is it the gender that you were born with? That's what God gave you, and that's the universal principle. I can't answer you that question, so I don't expect you all to answer it either. But I do want to make sure, because the ethics after the first class, which of course we missed our first two, we crammed it all into last week, but you sometimes can lose sight of the ethics part as we get deep into the law, and I'm a lawyer, not a philosopher, so we mostly end up talking about the law. But I just want to make sure we're remembering, okay, we've also got this ethics side of this class. So when you're thinking about all these different laws, and how do they fit into the utilitarian approach? How do they fit into the deontological approach? And how do they fit into the virtue ethics, the Aristotle virtue ethics, which is real archaic. What would the free market? How about the two newer ones? Free market ethics that says profit above all. Who would you side with there? Which approach would be more ethical under the free market ethics? Which is, how ethical is free market ethics? That's not a question. Stick with the Target. What do y'all think?
I'd probably side with Target because their corporation, but I mean, also, I guess it's just kind of like, you know, the corporation should be able to have free reign. Whatever the corporation can do is the most ethical decision. And if they feel that's the best decision for their bottom line, then they should be able to make that.
Yeah, I think that's exactly right. Do what?
Which group is, yeah, which numbers do you offend more?
Yeah,
Yes.
it's like, hey, which is going to make us more money, guys? And we go with that decision, right? So free market ethics would say, hey, if the people want to use whatever bathrooms they want to use, good. As long as we're in the black, we're good. You know, and what would the ethics of care, right? That says we're all interconnected and we all are one big happy family. Would probably say target as well, right? That's we need to be caring and we don't want to, isolate specific groups of people just because we don't like how they decide to live their lives. So the two new ones are both going to go for target. Deontology, who knows? Again, it's fairly subjective. And then utilitarian, that's subjective too. What is the greater good? Is the greater good making sure that we have traditional families so that, we keep a steady growth in population? Again, that's one, I don't know. Final exam is multiple choice. You don't really have to worry about that. You just remember utilitarianism, deontology, virtue ethics, free market ethics, ethics of care. So how about that in terms of sexual harassment at work? What is there was a brief little part in the book, there was the Meritor Savings Bank versus Vinson. Y'all recall seeing that? It was just a quick little blurb. So that one, basically what they're saying there is, if a plaintiff woman comes in and says, my boss or my supervisor in my office has been he hits on me all the time and is really inappropriate and is making aggressive sexual advances against me, right? And what the courts say is, in the context of sexual harassment, which is a little different from personal injury cases, is you don't have to prove any kind of psychological injury. So like in a personal injury case, if you get rear-ended in a car wreck and you fall out of the car grabbing your neck, which you should always do, and then call me. I'm just kidding. But you claim physical injuries, but then you say, well, I can't even drive anymore. I'm just scared to drive, and I'm psychologically damaged and I'm depressed. Well, you got to go. You got to get a psychologist to say that. I've been going to therapy, and he says that I'm all screwed up because of this wreck and my mind's a mess. You have to actually prove it. In sexual harassment cases, you don't have to do that. You don't have to prove some kind of psychological injury, because often in these sexual harassment cases, the extreme ones, you'll have physical aspects to it, but generally there's not going to be, it doesn't rise to, rape or sexual assault. It happens, but a lot of these cases, it's just inappropriate behavior in the workplace, right? Inappropriate sexual advances. In those situations where and that's, the courts have found, they'll routinely find that violates Title VII, because that ultimately is discrimination based on sex. Even if you're hitting on your secretary, that's discrimination based on sex, right? So you don't have to prove a psychological injury. You only have to prove a reasonable perception of an environment that is hostile or abusive, and that the plaintiff actually perceived it that way. So, and that's often in the law, they'll say, particularly in criminal law, there has to be a reasonable person, not just this particular plaintiff, but a reasonable person would have to perceive what has been alleged, this workplace environment in this context, as hostile or abusive. And the plaintiff herself or himself has to actually have perceived it that way as well. So a plaintiff can be unreasonable and say, well, no, I never really perceived it as hostile, but the law, I want some money, I'm going to sue anyway. If you don't actually perceive it that way, then you're not going to be able to recover. And then there's that on-cale or on-cale, however he says it, versus Sundower Offshore. They don't really tell you what that case is about. I'm guessing Sundower Offshore Services sounds like, they provide staffing for big fancy yachts or something. But that case, essentially, that expanded Title VII protections, didn't expand it, it just held that they interpreted it to say that Title VII in the context of sexual assault protects men just as well as women. And it can be, I guess the harassment or the abuse it can be to members of the same sex. So a man that is, makes sexual advances to a male employee under his supervision, that's actionable under Title VII just as much as if he'd done it to a woman, and the same vice versa. If it's a woman in supervisory position, can do it to a man or a woman, and it can still be a violation of Title VII. They're applying that equally, regardless of sex. Let's see. Now, the Vince versus Ball State, that case, and there's some pretty aggressive dissent. The book talks about, I'm sure it was Kagan and Ginsburg that filed some pretty aggressive dissents, but the Supreme Court basically held that a company is only strictly liable for violations of Title VII in sexual assault cases where the offender has authority or is in a supervisory position over the person that's complaining of the harm, over the plaintiff. So it can't be if they're employees on the same level, you're sitting there at your cubicles and you're sitting there sending dirty emails or whatever it may be, making sexual advances to a fellow coworker that's of the same level. That person can get in trouble, but the company is not going to be held strictly liable because they're not going to say, and there's good policy reasons for that. You don't want to say a company is liable for every single thing that an employee might do, even if it's to someone that's a higher up or the same level as them. But once you get, for your all's purposes, because everyone here is going to be in managerial or supervisory positions. Of course, none of you all would ever do any of these horrible things, right? But it's just something to be aware of. It's not, it's the supervisory position, because what the courts are looking at is there's a power disparity, because it's not just, hey, this guy's a creep and he's hitting on me all the time. It's, he might fire me if I don't, if I'm not receptive to his advances, right? And that's not really the main purpose of Title VII by any means, but that's why the courts look at it that way, is there's a power disparity. This person's going to feel some sort of obligation or fear. I'm going to lose my livelihood. I'm not going to be able to support my family. If I don't say, thanks for being a creep, basically. So in establishing a hostile work environment, what does a plaintiff have to show? Yeah. Now there's a four-part test that the courts look at to determine or to whether, that a plaintiff has to show. There are four things a plaintiff has to show to establish that there is a hostile work environment in order to bring that Title VII claim against a business, right? Yeah, protected group. And that's, hell, it could be everybody's in a protected group. I'm a man, or I'm a woman, or I'm, transgender, whatever the case may be, you're in a protected group, right? And this is not just in context of sexual assault. This can be in the context of, you work for a company and let's say you're Hispanic. And we see later in the book, or later in this chapter, there's, the one city that required all the 29 Spanish-speaking employees of the city said, you got to speak English. You can only speak English, right? And that's where they'd be a protected group for national origin, right? So you got protected group, member of protected group. What's the second one? Yep. And again, that's, if we're looking at, that's specifically in the sexual harassment context. It could also be, can apply that test just as easily to, racist conduct or discriminatory conduct based on being Hispanic in that instance. Okay, 3. Yeah, exactly. So because in sexual assault context, because I'm a woman or because I was a man. And then 4, and this is the big one.
Bad enough level, severe enough.
Yeah, it's sufficiently severe or pervasive to alter the terms and conditions of employment, which sort of sounds weird, right? Alter the terms and conditions of employment, terms and conditions. That sounds like what we were talking about, you click on for iTunes, terms and conditions, right? But they don't mean those kind of terms and conditions. They mean, okay, the conditions of your employment are now that you have to endure sexual harassment from your boss, right? So, and what they'll look at there is the frequency, the severity, if it unreasonably interferes with work performance, and which one judge, I think in the case there, he says it's no less difficult than trying to nail a jellyfish to a wall. Many of y'all tried to nail a jellyfish to a wall? Yeah, I've never been able to get it. Slippery little guys. But, and they do point out in the book, and this is very fair, that the outcome can really depend on what a particular judge finds offensive. So you get in a good old boy state, you're in, Alabama, and you got some really cantankerous old judge. He's probably not going to be like, that's not offensive. But if you're up in New Jersey and you got a younger female judge, you'd be like, this is horribly offensive. This definitely violates Title VII. Old Alabama judge may say, nah, seems fine to me. I was the second firm I worked for, it's an insurance defense firm. They're based out of Georgia. I was in the Knoxville office. We went down for this firm retreat at some, golf resort or something. And they had a Georgia judge there, was doing a PowerPoint, giving a presentation on workers' comp. It was a workers' comp defense firm primarily. And he gets up there on his PowerPoint and he throws up a picture of the Victoria's Secret models with the angel wings and starts making all these kind of creepy references to it. It was very strange. He's an very old judge. And maybe he just didn't care anymore, but it's like, what kind of judge is this? There are women here. What are we doing? But he's the kind of judge that probably would not find Title VII violations in many cases, at least in sexual harassment context, right? He'd be like, boys will be boys. So it can depend. Now, I'm not saying that's good. It's actually bad. But judges, the particular judge you have can often have an influence on the outcome of your case. And that's true with every kind of lawsuit there is. Judges are people too. They have their own, kind of prejudices. And I don't mean race, bad prejudice, but they have their own views of the world, and they have their own life experiences that'll influence how they'll rule. Ideally they should, and it should always just be a neutral application of the facts to the law and what's the right result. But again, they're people too. We're all fallible. And that's just part of the human experience, right? So about racial discrimination. And we don't really the book doesn't really give us many cases to talk about there. And I guess you've got the Spanish-speaking language case, but the book has that article talking about racial discrimination. And that's obviously still a hot button item of debate right now. They kind of talk about structural racism or systemic racism, where you see the cumulative effect of government policies have created kind of an unfair disparity in the success that particularly Black people in America, right? The book, unfortunately, doesn't give us a whole lot in terms of to discuss or talk about. It's kind of there. I'll open that up to if anybody has any thoughts on that, is there, how pervasive is structural racism in this country? And is it nationwide? It's kind of a heady topic, right? So you don't want to say a whole lot. I'll say for, particularly in Knoxville, you see in a lot of cities when they started building the interstate systems and you see overpasses and stuff, they would often go through minority neighborhoods. And these interstates would often cut those neighborhoods off from where businesses are, local businesses where they might find employment, cut them off often from, a lot of grocery stores. They wouldn't have access. They have what they call food deserts, right? They don't have access to as healthy a food. So you get health problems that kind of stack upon themselves from lifestyles that aren't as healthy as they could be. There's also, in Knoxville at least, they tore down, there was a Black neighborhood in East Knoxville, where you had, I mean, there was a lot of single family homes and duplexes where you had families that were doing pretty well. And a lot of them owned their own businesses and had a pretty thriving little community. Well, what the Knoxville government did is they say they had this new vision for Knoxville. And they came in, they bought up all those houses. I mean, exercised eminent domain to do it. It's not like these people willingly sold them. They said, we're taking your house and here's what it's worth. Here's your money. See ya. They tore them down. They built a bunch of projects. And that ended up being a real detriment to the Black community in Knoxville. And that Knoxville's not the only place that happened. So that's, and again, here, what does that really have to do with business law? A good bit, you know, because opportunities aren't there for people at the same, there's not an equal playing field of opportunities for people that have, you know, kind of were pushed into projects, kind of pushed into ghettos to an extent. You know, it's not like it was Nazi Germany level, but, you know, government policies force these people into a situation where the playing field is not level. If it ever was, it's arguably it never was for them. But so it's kind of, and you know, they talk about in that article about employers. They look at the quote soft skills. You know, there's well, they want people that you know, they look a certain way or they act a certain way, speak a certain way, and so they would often not want to have minority, and again, particularly Black workers be in certain fields or certain parts of the business. They don't want them interacting with consumers or customers. And that, you know, arguably you've got a Title VII implications there, you know, that these employers are saying, you know, I don't want these people because they're not as good. They don't interact as well with customers, you know. But they're not saying, oh, this particular person, his personality is such that he doesn't interact well with customers. It would often be Black workers don't do it as well. So we're just not going to have Black people be up front talking to customers. And that's not really fair, is it? And that's going to kind of conclude the racial discrimination side of it. Again, I don't have any good cases to talk about, but does anybody have, I'm going to open the floor there briefly. Has anybody's got any thoughts or wants to tell us about any times they particularly witnessed what might be considered structural or systemic racism? Okay, we'll move on to religion then. So the religion, we do have some good cases to talk about. You got the Webb versus City of Philadelphia. What happened in that case?
Job.
Mhm.
She was a police officer.
Mhm.
I told her now that she
No.
because it's a religious.
Mhm.
You
Yep, and their policy, what was the police departments, what was their policy there?
I think it was just like you can't wear like religious iconography. Or something.
Yeah.
That kind of terminology.
And it was like a blanket, you know, no religious iconography of any kind. We don't support any religion at all. And we don't even support atheism. No religion, you know, just, we don't even talk about religion, right? How did the court rule in that case? Did they say that there was religious discrimination? No. Why was there not religious discrimination in that case?
Because police department was trying to present a unbiased face to the public in their interactions with the public.
Right.
The public's willing to come up to any of them and talk to any of them.
Yeah. Now that's right. What is the test, or what does a plaintiff have to show in order to prove or to shift the burden to the employer to say, okay, I've established a prima facie. Now, we all know what prima facie means, a prima facie case. Yeah, so that's an example of, okay, here are the elements to establish a prima facie case. And applies to a prima facie. That means like on its face, you know, at first look, this is a case that'll win. You know, I've established a prima facie case of religious discrimination. And what happens when you've done that is the burden then shifts over to the employer to say, no, this isn't actually religious discrimination, even though at first look, it might be, we've actually got, reasons why it isn't. Here we can show you why it is not a case of religious discrimination. So what does the plaintiff have to show to establish that prima facie case of religious discrimination?
That she's a sincerely held religious belief.
Yep.
She informed the employer of the conflict,
Mm-hmm.
and that they were disciplined for failing to comply with the conflicting requirement.
Right. So that's what the plaintiff has to show. If there's alleging religious discrimination, say, I've got a sincerely held religious belief. I informed my employer, of that belief and of the conflict that my religious belief has with this established policy. And I was disciplined for failing to comply with that conflicting requirement. So
Establish a sincere.
that's almost always going to be established by the testimony of the plaintiff. So, and now the plaintiff could get in there and lie, right? Yeah, that could happen, but judges weigh the credibility of witnesses and of parties routinely. That's like a major part of their job. And it'll also, if it goes to a jury trial, the jury, you'll have 12 people and people are like, oh, what do they say? If you're not smart enough to get out of it, there's something about only the dumbest people can't get out of jury duty. I mean, that's a nice joke, but juries really are it's pretty remarkable. They get to the right decision pretty much every time. And there's a reason why jury verdicts are incredibly hard to overturn. You can get a judge overturned, the judge can screw it up. But if you've got a jury that says, no, here are the facts, they're the fact finders. And if the jury says, these are the facts we found, we think this person was credible, and their testimony to our minds establishes that this was a sincerely held religious belief, that's not going to get overturned. No court of appeals is going to touch that.
So zero is just a testimony for the person.
Yeah. Now, the employer can come in there and say, well, it's not actually true. Here's some emails she sent making fun of Muhammad, and she said she was Muslim. No Muslim would do this. And the jury would say, oh yeah, we don't believe her. That's not sincere. But again, testimony, people will often say, well, you can just lie. But when you get somebody and they're under oath and you're an attorney's grilling them and the judge is sitting there looking down at them, if they're lying, they'll crack pretty quickly. And that's something you do in like depositions and stuff. You can ask people questions, you break things down, and you can get them. The first 10 questions, they might be like, they're holding true to the lie. And then by the time you get to the 20th question, they start saying things that are inconsistent. And by the time you're an hour in, they just fall apart if they're not telling the truth. And if they are telling the truth, they won't fall apart. And you'll know, okay, this is a sincerely held religious belief. They're not just saying it to get out of work or to make some money in a lawsuit. Which certainly there are people that will do that. They will lie, but they often don't get away with it unless the other side just rolls over and settles because they don't want the bad publicity, which that happens as well. So when a plaintiff establishes that prima facie case of religious discrimination, shows those three elements, and the burden, like I said, it shifts to the employer, and then it shifts to the employer to show that they made a good faith effort to accommodate that sincerely held religious belief and to do something about that conflict, or that accommodating that sincerely held religious belief would work an undue hardship on the employer. And that's the key there. Was there an undue hardship for the employer? If there is, generally they're going to say, sorry, it would be too difficult for this employer to accommodate your religious belief, so we're not going to find religious discrimination. So in the Webb case, she showed, hey, she met the three elements: sincerely held religious belief. She let her employer know, and they disciplined her for not complying, with that conflicting requirement. But because the employer, that police department, their, Directive 78 or whatever, was clear that we must be religiously neutral because that enables us to best serve our community. And if we make an exception for her, then we'll start making an exception for, cops will have, their Christian necklaces hanging around, and then you might get one cop that's like a weirdo Satanist or something, and then it all falls apart. And so the court said they met that undue hardship burden. They said, okay, it would impose an undue hardship to force the police department to allow Officer Webb to wear the hijab, right? Then you had Kelly versus Johnson. They talked about the case in the 70s when everybody had long hair and all that crap, and the male cops wanted to have the requirements they had to have be clean shaven and, you know, hair not over the ears and all that. Did anybody see how the court ruled in that case? I didn't put it in my notes and I can't remember.
Wasn't one about the beards.
No, it wasn't the beard one. That was the city of Newark. Yeah, the Kelly, if anyone can see in the book what they say about the Kelly versus Johnson case, please, you know, chime in. But the city of Newark, that was the one where this police department, I guess the Newark Police Department, they had a policy that, you know, male officers cannot wear beards unless, you know, they have to have a beard because of some disability, you know, to basically to comply with the Americans with Disabilities Act. In that situation, you can have a beard. Well, there were people here, and I can't remember if they said they were probably Sikh, or they might have been, I can't remember what religion they were, but they said, well, listen, if you all can make an exception for the ADA and allow police officers to have beards if, you know, they've got some sort of disability, you know, then we should be able to have beards if we have sincerely held religious beliefs. And in that case, how did the court rule in that case? The city of Newark.
They had to make the exception.
Yeah. And the basis there, they don't really get deep into the court's rationale, but it seems to be that, you know, hey, if you're going to make an exception for the ADA, well, then you can't just not make an exception for sincerely held religious beliefs, because again, that's protected under Title VII, right? Now, what about, now someone last year made a really good point on the Beards case, and that is, what about gas masks? You know, there might be situations where police officers have to use gas masks, you know, if there's a big riot and they're, you know, sending out tear gas and all that, and they need to, you know, what if a beard, you don't get a good seal? Like I wouldn't get a good seal, and it's scraggly, but it's still, I wouldn't get a good seal, right? And gas would get in and I'd be coughing. I'm not shaving my beard, so I'll just tell you that right now. But I think that's a good point there. Would that be, does that really fall into the undue hardship there?
At work, I mean, we have jobs, people have to wear respirators.
Okay, what do you do?
They can have beards, but if you know you have to do respirator work or going to be on a job associated with that, you
Yeah.
have to shave. Like if you're at work, they can tell you have to shave.
What do you do? Where do you work?
Oak Ridge National Lab.
Oh, okay. Oh, yeah. Yeah, you want to wear that respirator for sure out there. Whew.
Not just like doctors though, like, and especially because of COVID, like people who have beards, I work in a nursing home and like all of our male employees had to shave because they can't like properly be fitted for an N95. So.
Right. Right. Yeah, they were saying early on, the articles were like, should you shave your beard for COVID? And I was like, I'll just get the COVID and to hell with it. I've seen myself without a beard, and that's never again. But you know, that is there are legitimate concerns there that, yeah, well, what do you do? And if you say, okay, the court's ruled, these people have sincerely held religious beliefs that say they can't shave. You can't make them shave. What do you just not have them involved? Okay, if we've got a riot and you got to have gas masks on, we're gonna be shooting tear gas. You know, you guys, you go to the back and you know, you'll be the backup or something like that. You know, who knows? And that's a point that that obviously wasn't made to the court then. That might have changed how they viewed the case. If someone had said, well, hold on, you know, we got this policy for gas masks. That might have been a good way for the employers to get around allowing these people to have beards. But sometimes it's easier to just say, grow the beards.
What's the medical reason for needing a beard?
Well, actually, the book talks about, I can't remember, I think it was the book that said, particularly for African American, for Black men, that something like 60% of Black men have, they get very painful bumps when they shave, and it can, you know, cause a lot of skin problems. And the way to fix it, grow a beard, and no more skin problems. Well, you have a beard, Austin. Why are you complaining?
Not posed.
Come on, man, this helps us. But now that's an example where we have a medical. I've been trying to find a medical reason for mine, but whatever. Yeah, skin bumps. But that isn't. That's probably why. That might have been the ADA exception that Newark had prior to getting hit for where you have to have a religious exemption as well. And that again, that kind of goes to we're equally applying the law, right? That's kind of the broader overview of what we're talking about today is equal protection under the law. You can't say, well, we're going to protect people that've got disabilities, but we're not going to protect people with sincerely held religious beliefs. Can't do that. So yeah, but again, circling back, web case, like I said, Turner, that was dismissed, and the importance of the appearance of religious neutrality met the undue hardship burden. It would be an undue hardship to undo that appearance of religious neutrality for that police department. And that kind of also shows you how you can get different courts will give you different results. The Newark case, obviously religious beliefs were important to them. But again, you had the converse of, okay, you make an exemption here, you got to make an exemption over here as well. So let's consider some examples. So they got in the book, they talk about the HR, if you're head of human resources or you're making decisions for the human resources department of a company. So would they have the California or like some clothing company, and they said, okay, we want all of our employees to wear skimpy little skirts and ripped up jeans and, short little shirts and revealing, they call it laid back California style. And this girl is working there, then she converts to an apostolic religion that says you got to wear long skirts and loose long sleeve shirts. That's what her religion requires. What would you do as HR in that case? We've got this company policy, you got to wear ripped up clothes, buy $80 pairs of jeans that already have holes in them. Makes no sense to me. But and this woman, she converts and says, well, no, I can't do that anymore. I have to dress like plain Jane. How do you handle that if you're HR? And let's say it's a sincerely held religious belief. She said, this is sincere, I've converted and I'm serious about it. She meets the Prima Fascia case. What do you do? What do you need to show to overcome her Prima Fascia case? Undue hardship, right? How would you show could you show an undue hardship there?
You'd have to show that laid back California style is important to the perception of the business.
Yeah, that's pretty much the only argument I think you can make, I think. But yeah, that'd be the exact argument I would make is, listen, our customers, they come in here, they expect a certain style, and that's what they're coming for. And they come in and they see the woman at the cash register, it looks like she just got off the churning butter at the farm with the Amish. They're gonna be like, well, you don't even wear the clothes you're selling. How good of an argument would that be? That may be one that would just depend on the judge or where you are. If you're in a more liberal area of the country, you got a more liberal judge, that might not be a good enough argument. If you're in, rural Tennessee, that's probably a pretty compelling argument. You're not going to have a store like that in rural Tennessee, so the issue would never come up. But yeah, that'd be pretty much the argument you'd make, is we have a certain image that we're portraying to our customers, and that's what we need to have. But that's one that would probably be, could go either way, again, depending on where you are, what kind of judge you have. So let's say the Jiffy Lube one, the Jiffy Lube grooming policy. They say, okay, we're going to clean up our act here. You're all too scruffy. Shave your beards, trim your hair, cut your hair. And if you're going to be one of the, if you're going to be having customer contact, if you're an employee that has customer contact, you got to be clean shaven and you got to have a nice haircut and look nice. And they say, okay, we've got an employee here. He's a technician and he's a Rastafarian and he hasn't cut his hair, shaved his beard in 23 years. How do you deal with that? He's a technician, and it says, well, he wants to work in the upper bay where it's nicer, easier work environment. In the lower bay, it's cold and more dangerous, and he wants to work in the upper bay. How do you handle that?
Is the upper bay customer contact?
That's my question. The book doesn't, I'm looking, I'm like, he's a technician. It sounds like he's not gonna be involved with customers at all. He's just working on the cars. That'd be the response.
The guys, if you pull up and they want to put in the car,
Yeah.
versus the guys that are.
Now, it's Jiffy Lube, you're supposed to just pull right in with Jiffy Lube. You don't drop the car off. I don't know. I've never been to Jiffy Lube. I go to Fisher and you just throw them the keys and go about your business. If you have a ride, I guess. Yeah. Or you just sit there. But yeah, that's one it's one of those examples where the book doesn't do a very good job. It's like, okay, so I guess they're implying Upper Bay, you're going to be directly interacting with your customers and they want them to be clean shaven. And this guy, he doesn't want to work in the Lower Bay. Was that one where you can say, you like working in the Upper Bay, but you're a technician, you're going to work where we tell you to work. Is that what you'd say there? Or would you try to make an exception for him?
Does it matter if you're changing your policy versus if it's been in place?
No, it doesn't really matter if you're I mean, unless you've got, it can matter if you've got written employment agreements that says, okay, this sets out our policy. And then you come in, okay, we're changing our policy. Here's the new employment agreement. And they say, well, this isn't what I signed up for. You have some contractual issues, but it would basically just be, if you don't like the new one, you can leave. In terms of what we're talking about here, it doesn't really matter. It's still Title VII applies, whether it's you're changing your policy or you're a new company and that you're establishing a policy or whatever the case may be. Title VII is what it is, so to speak. It's going to apply regardless. So that's one that, hey, just work in the Lower Bay. It's not that big a deal. And if he says, I don't want to work in the Lower Bay, and you say, okay, we're going to fire you because you won't work in the Lower Bay, he could still turn around and say, well, the reason you wanted me to work in the Lower Bay was because of this policy that discriminates against me for my religion. And then it goes back to that undue hardship. Can you show that, hey, having clean cut customers, is important to our business, makes an appreciable impact on our business? I don't know how good an argument that would be because you're just getting your oil changed. Who cares if the guy's got a beard or not, as long as he changes the oil, right?
Yeah, but so extend that into anything you want. I mean, tattoos and piercings or
Yeah.
I mean,
Well,
grooming, whatever. I mean,
we're
so
talking
whatever
about sincerely held religious beliefs, right?
Okay, right.
So and I don't know, there may be a religion out there that says you got to have, tattoos as part of the deal, and if you don't have the tattoos, you're just, you're faking it. You're not really one of us. You're not whatever that religion would be. I don't know. Is there a tattoo religion?
Not yet.
I don't know. There will be soon, right? That's very sincere. I don't know. That again, you'd have to have some kind of sincerely held religious belief, and you can't just like make up a new religion. That's like, I'm a tattooist, meaning not a tattoo artist, but like a tattooology. And it's like, I genuinely I believe in tattoos and that's my faith. And I'm very sincere. Yeah, that's not going to fly because that's not, you're just making stuff up to get away with having tattoos, right? But yeah, you're not going to really get religious implications there generally. And there might be certain examples, you've got a cross tattoo or something like that, or a crescent moon tattoo. Maybe it'd still be a stretch there. And with tattoos, it's, just wear a long sleeve shirt and you'll be okay. But yeah, that would be a much tougher case for a plaintiff to prove because, like Rastafarian, they legitimately grow the hair out, grow the beard out, and you don't cut it, right? And that's part of the religious belief. With tattoos, that'd be a much tougher road for them. It'd be a harder case for them to prove. I'm not saying it couldn't be done. And again, depending on where you are, you might have luck, up in Newark or something, you might get away with it. Or the judge might say, okay, down here, probably not. How about, so they talk about the dress and grooming examples where you have males can't wear, bank says, okay, male tellers cannot wear earrings, can't wear earrings. Now that one goes more to gender stereotypes, right? That's not so much talking about religious discrimination. We're talking about discrimination based on gender and kind of societal norms with respect to how women should appear versus how men should appear.
sex-based rules, right?
Yeah. So,
I think you'd have to have a stretch of that, like, men wearing, like, you'd have to prove, like, you said it was like a bank,
yeah,
like, a bank, like, would have to prove that, like, men with earrings somehow appear less trustworthy with money. I mean,
but that's,
Isn't that part of?
glad I don't have earrings, Turner. I mean, man. But,
Case brief or whatever, right, we talk about anytime, like applying sex-based rules, would that be
yeah.
part of their reasoning?
Yeah, it is. And I think, and you got to remember, the law is evolving pretty quickly. Even when this book was, it came out in, I don't know, 2018, 2019, and we're already seeing what the court is just rapidly saying, okay, hey, yeah, earrings, those are, anybody can wear earrings, right? But, men wore earrings like in the 1600s in Europe, it was men wore earrings and that was like totally fine and normal. But that's one that, yeah, I do think it'd be a tougher case probably for a plaintiff, especially in a bank, in the context of a bank. If it was Jiffy Lube, it might not be as important. They might not be able to say, hey, it's an undue hardship for us to, if you force us to allow men to wear earrings while they're, changing the oil out on a car, versus a bank that's, dealing direct customer interaction all the time. And depending on the kind of bank it is, you might have a certain type of customers that expect not to see men with earrings. And if they do see it, they're like, give me my money. I'm going to a different bank. Right. What about the casino example? So they say, okay, women have to wear stiletto heels and makeup, and the men can wear whatever dress shoes they want, just some dress shoes. Who cares? Pretty discriminatory. What do you think?
I mean, if it's like just like infinitely more specific for the women and more restrictive, I would say so. Like if the male dress code is just like any shoes or any dress shoes, I feel like that's discriminatory. You're imposing unnecessary restrictions on the women.
Yeah, I would think so in that case. I mean, does anybody disagree? They might think that, hey, it's a casino. The women need to be all done up in makeup and wearing big old high heels. Now, it's pretty clear that's sexual discrimination, I would think, in that case. And now this goes to the example of what would be the medical read. This is a pizza company that says, okay, all of our people have to be clean shaven. And that's where they gave the example of, well, 60% of Black men, experience horror, have negative reactions, or they have skin problems caused by shaving. And if they just grow a beard, they don't have the problems, right? They don't get the painful shaving bumps. Is that one? Now that kind of implicates, you've got the ADA implication there, and then you've got potential like racial discrimination kind of tied together in it. How important is it for a pizza company to have clean shaven delivery guys or clean shaven guys making the pizza when they can just wear the beard net, right? Does anybody think that would not be discriminatory and that'd be a totally fine policy? Maybe.
I mean, it's just like with the girls having long hair, like, clearly they have to put it up, but like you said, they can just wear a beard net and it'd be fine.
Yeah. What would there be an undue? And that's where you look, is there some kind of reason? Is there a good reason? Not just a reason, but a good one for the employers to require, that all the men be clean shaven. You're probably not in a pizza company. Do what?
Especially not for the drivers.
Yeah, like how much do customers really care about? They care more about how high is the pizza? Did you get the right toppings on there? Not, listen, this guy had a beard, I'm weirded out. The pizza was good, but I'm not going back to you. The beards, they creep me out. Who says that? Let's see. So religion. So delivery driver, works for UPS, and he says, I am not delivering from Friday and Saturday. I don't do any deliveries. That's the Sabbath. I ain't doing it. no deliveries. How do you respond to that as an employer? Do you say, well, if you don't do deliveries when we say you do them, then you're fired? Or do you make accommodations there?
I mean, really, the employee should have, known that they would make the deliveries on Sundays, and if they still signed up for the job, then it's on the employee.
You think so? Now, what if the employee didn't know, they just come in, they're like, hey, we want delivery drivers, and they come in, they say, you're going to get these benefits, and you only have to work 5 days a week, and it's going to be great, and, we provide the van, and we provide the uniform. Like, okay, when do I start? Next week. And you get in there and like, all right, we're going to have you deliver Friday, Saturday, and Sunday. It's like, whoa, wait a second. That's when I'm observing my Sabbath. I can't make deliveries on that day. If they didn't, so let's say the employee didn't know, when they got the job and it never came up and they didn't think to ask, oh, by the way, I can't work on these. I guess to your point, should the burden be on the employee to say at the outset, before I take this job, I can't work on these certain days for religious reasons.
I feel like that would be a fair thing for the employee to do, but also if the employer didn't know and the employee didn't say anything and the employer fires him after that whole video, him saying that I can't work on Sundays, it just kind of is burden to the employer because he needs somebody that works on Sundays. So really it might not be discrimination against religion. If
No.
he treats another person with a different religion, the same thing that doesn't want to work on Sundays.
Yeah.
If that makes sense.
So that's one side of it. And they could say, listen, I've got, this guy's Sabbath is on a Saturday and we got another employee's Sabbath's on a Sunday. Well, I don't care who's what religion or when the Sabbath is. You make the deliveries when I tell you to make them. And I don't make any, I don't discriminate at all. Well, the courts are still going to probably look at, again, let's assume these employees can establish the Prima Fascia case. Can they show it's an undue hardship on the employer not to have this person doing deliveries on this Saturday or Sunday, whatever their Sabbath day is, right? They could say, well, the courts will probably in that case look at, okay, is this a local delivery company and they got like 4 employees and they have to have somebody covering shifts like you're saying, or is it UPS or FedEx and they've got a team of people? And it's like, well, just, shift the schedules around and get somebody to deliver it on Saturdays who does not have this sincerely held religious belief that says I can't work on the Sabbath, right? So that's where there's going to be some, you kind of look at it as case by case basis to a certain extent. Is what's the employer situation, hey, and that's the undue hardship analysis.
So what if you had this guy just got promoted or whatever it says, but it was like a seniority thing within the organization or union or whatever it may be.
Is
that play into it?
You mean in terms of, well, flesh that out a little bit.
So shifts are selected based on seniority. You just moved up to driver.
Yeah.
Which I think is what it said, right? You just got promoted.
Yeah.
So you're at the bottom of the totem pole, and this is the shift that you get when you first come up. Does that make any difference in these decisions?
Again, that it's going to come down to, well, one, it's going to come down to the employer's policy is going to be, is it truly religiously neutral? Sort of like looking at that police, their policy and no hijabs, we got to be religiously neutral. Does the employer have a policy in place that says, we don't care what your Sabbath is, we're not going to have any sort of religious observations of any kind. We're a religiously neutral delivery company, right? You'll have that might factor into, that might be a factor that a court would consider as important. But generally, whether it's, hey, you just got promoted versus you were directly hired as a driver, that's generally not going to factor into these sort of analyses that much. That's, again, generally. Every case is unique. Facts are always, depends on what the company's policy is, size of the company, those sorts of things are always going to play in. But generally, whether they were hired at this level or they got promoted to that level, there's not going to be a big distinction there in terms of how the court's going to treat it. Does that make sense? Does that answer your question?
Yeah.
Sort of.
Yeah.
Is it good enough? So let's see. So here we get into the Maldonado versus City of, I'll trust if I can read my writing correctly. And that was the English only case, right? So they had, well, what happened in that case? Who remembers?
It was the city that banned like speaking Spanish.
Yeah, but how did it start out? You know, they didn't just say, you know, that we're banning speaking Spanish. You know, there was,
Spanish on the radios.
yeah,
The English only speaking employees were complaining because they couldn't understand what was happening.
yeah,
And weren't getting the communications that they may need to be getting.
exactly. And it started out, you're like, well, that makes sense. And then the guy, like the supervisor, Willis or whatever his name was, he calls up and he says, listen, they're speaking Spanish on the radios. We don't know what they're saying. And they said, tell them they can only speak English when they're using the radios. Well, what does Willis do?
Only English all the time.
Yeah, he says, listen, you can only speak English, period. And we're going to be implementing a policy. It's coming. You just wait. It's English only all the time. And that created a lot of tension, right, with the workers. They're like, well, it was kind of they viewed it as an attack, right, on them as Hispanic people speaking people. Like they felt it was almost sort of like an attack on their ethnicity or on their national origin, right? What happened? How did the court rule in that case? Or what claims did so they did ultimately end up, like they said, it ended up being, okay, you can't, no one can't speak English at all on any of the job sites when you're on, when you're on duty for the city, English only, no Spanish. What claims? They brought two principal claims. What were they?
Discrimination on their ethnicity.
That was one.
Couldn't that put them in right of speech?
Yeah. Did you say freedom of speech?
Yeah.
Right. Yeah. They was in the First Amendment claim,
Yeah.
right? So the First Amendment claim was kind of like they were in the court made this big old example about T-shirts. I can't remember. Did they actually have T-shirts? It was never clear. It was like, and then Yankee fans versus Boston fans. I'm like, that is a really bad analogy. It's like sports. Come on, man. Sports. We're talking about bigger issues here. But not that sports aren't great, but I mean, how good of an analogy is that? But how did the court rule on the First Amendment claim? How did the majority? There was a dissenting opinion, but how did the majority rule on the First Amendment claim?
I think the majority ruled against that, correct?
Yeah, and they said this doesn't really implicate freedom of speech. We're talking about, not being allowed to speak Spanish when you're on, on the job for the city. Does that really implicate the First Amendment? No, that's not really a First Amendment claim. That's more of they haven't been prohibited from speaking. They've been discriminated against. They said you have established a claim. In the court, this was, I think, an appellate court that basically just said they've established enough of a claim that they're not going to get kicked out on summary judgment. Now, do you all know what summary judgment means when they talk about summary judgment in the case? What summary judgment means is that there are no disputed facts in this case. So we don't need a jury to look at this. We don't need a trial. The judge can simply decide what the outcome is as a matter of law. We say, here are the facts. No one's disputing who said what or who did what. It's just a question of how does the law apply to these facts. And if the judge says, okay, you filed this motion for summary judgment, none of these facts are disputed, and therefore the law says this should be the outcome. What the appellate court was saying here is, as to the Title VII claim, the discrimination claim, that they had alleged enough facts that they could not, they're not going to be kicked out just as a matter of law. There's enough that they can go to a trial, have a jury, listen to the testimony, and decide what the right result is, decide whether there was in fact discrimination based on, national origin or ethnic origin. So they did find there that, now what was the kind of why did the court find that they had stated a claim for religious or for ethnic, for national origin?
Part of it is the way they were being treated, like the police officer saying something to them and Willis telling them they didn't want to tell it in front of the other employees because they make fun of them or something like that about it.
Yeah. So, but when there was, they also made a big point of, this is not a case, what one of the judges said, I don't remember, it's the majority of the dissenting, but he said, this is not a case that's about, an isolated incident. One employee, felt like he was discriminated against. It was, it was pervaded through that whole department in the city. And you had 29 workers that were basically, it's like they were standing off against each other, right? It was, those workers felt like they were truly being attacked and discriminated against as a whole group based exclusively on the fact that they spoke Spanish and the fact that they were of a certain national origin, right? So that was that case. Anybody have any questions on that one? No? Okay. What about women in the workplace? And this is kind of looking at the book talks about, this different choice versus stereotypes. They talk about, a lot of women will choose to focus on their family, to the detriment of their job, but not all women choose to do that. But there's still a stereotype that, women are just inevitably going to focus on their family over their job. Right. And so what does Title VII say about that? Is that acceptable? No. So when they say like a good mother is, the stereotype is a good mother is always available for her children, whereas a good father always provides for his family. So he's going to work hard, but the mother's going to, neglect her job to be available for her children, right? So, Title VII basically says, hey, we can't just look at these stereotypes and say, my gosh, is it 8 o'clock? We're having so much fun here. You can't employees just can't assume based on stereotypes, how they're going to treat women versus men with respect to their families, with respect to their family status, whether they've got children or something like that. And that kind of plays into FMLA. Now, any of you all that have had any kind of, salaried positions or anything like that, you've heard FMLA. What does FMLA stand for? Yep. Family Medical Leave Act. Now, what does FMLA mean? What does that mean in application? What does that law tell us happens? What is FMLA? Yeah, I mean, what does FMLA leave mean?
Extra job,
Yeah. You can take,
medical care reasons.
yeah, there are certain, there are like 5 specific categories that you can take FMLA leave for. And I don't think the book tells you, but you get 12 weeks and they don't have to pay you, but they have to protect your job, and you have to get your job the same job for the same pay has to be there for you when you get back after you've taken your FMLA leave. Again, it's 12 weeks, right? So what are the 5 areas or 5 categories that you can take FMLA leave for? Childbirth. So, and that's, okay, that's, and when you say elderly parents, I mean, it's a little bit broader than that. You can do death in the family. That kind of, is that one there? Not really death in the family. 12 weeks, that'd be a long time it's a long grieving process. But I understand it. I just lost a brother 3 months ago. So it is but is it an FMLA category? Is it something you can take leave for that long? No, you might be able to take like a week. But for FMLA, you got children, that's birth, but that also includes adoption. If you adopt a child, you can take FMLA leave for that. When you're talking about elderly parents, again, it's a little bit broader, but you can take FMLA leave to care for immediate family members. That can be your parents, that can be your children, wife, husband, whatever the case may be. And that's to care for an ill immediate family member. Can't be your second cousin down in Florida that's got a fishing boat and gosh, he's real sick. Got to get down there and help him out. The only cure is more fishing. Let's see, what's another one? If you yourself are sick, right? You can get up to 12 weeks unpaid leave if you are dealing with a serious illness, right? And then the fifth one, which is not unique, but it's sort of more narrow, and that's if you've got an immediate family member that has been deployed and is in the armed forces and has been deployed. You can take FMLA leave for that, which is, that kind of asks the question, Don, you were going to ask something? No. That it does ask the question, to Mary's point, is can you take, if you have an immediate family member that's killed, say in Afghanistan, gets, God forbid, blown up by an IED or something, you could arguably get FMLA leave for that death, because it would be related to the deployment, of an immediate family member in the armed forces. So potentially, in that narrow situation, you could get FMLA leave for that. But as far as just an ordinary death in the family, no. But if you've got a family member that's really ill and is going to die, you could get the FMLA leave to try to take care of them. There are some exceptions, and the exception is to whether they have to give you the job back. And that's really for like the top earners, the top 10% earners for a business within a 75-mile radius or something like that. They can deny, they basically can say, we're not giving you your job back if you're one of the higher income earners for a job. And it's similar to the Fair Labor Practices, FLPA, Fair Labor Practices Act, where, and like wages, you have to pay overtime to hourly employees, but people who are on salary, higher earners, you can work them 80, 90 hours a week, and you haven't violated any sort of federal law, right? Yes.
Do you say that FMLA protects after 12 weeks, they don't have to pay you, but they protect your job?
No, it's 12-week period. They don't have to pay you for any of that 12 weeks under FMLA. And they have to, in that 12 weeks, your job has to still be available for you at the same rate of pay. They can't take your job away or say, well, welcome back, haven't seen you for 3 months, you've been demoted, here's your new, broom closet you're going to be working out of. They can't do that, right?
After 12 weeks, they can tell you.
Yeah, if it's like, listen, you've exhausted your FMLA leave is what they'll tell you. And it depends on the employer. If you've got an understanding employer and it's a situation where, hey, you're still dealing with, your mother's got cancer and severe, it's highly advanced and you're the primary caretaker for, the employer can leave that job open for you, but they're no longer required to. It's not a set, all right, after 12 weeks, you don't have the job. The employer can still say, hey, we're going to hold it for you. But they're not required to under the FMLA. Let's see. They did in the book ask, does making same-sex marriage is now constitutional, right? I think they cited they said the Supreme Court made it constitutional. They cite some 2013 law, but pretty sure it was Obergefell in 2015 that actually made same-sex marriage constitutional. But they ask, does making same-sex marriage constitutional, does that change how the FMLA applies? Or does it implicate the FMLA? Yes? No? Well, we talk about, there are the 5 categories, right? Birth, adoption, taking care of someone who's sick, you're sick, family members deployed. Is marriage really involved in there? No. You can still now, same-sex marriage, it's not likely to result in pregnancy. I guess 2 women could get married and there could be, artificial insemination or something like that. And one could be pregnant, and then a same-sex male couple or married couple could adopt, and then you would have FMLA relief there, right? Now, so that's not really going to change how it applies. Do they need to amend the FMLA to say, to factor in the Supreme Court's decision on gay marriage or same-sex marriage, I guess? No, not really. All right. Now, what about do you all want to take a quick break, or do we want to power through? We've got not a whole lot left, but I'll put that up to you all. Break or no break? Power through. Courtney says no.
Yeah,
Power through. Yes, break?
yeah.
Okay, you all vote. Break, show of hands. Who wants a break? I got one. That's one, but it was two hands, but it's only one person. All right, who doesn't want to take a break? Power through. Democracy in action. We're powering through. Sorry, guys. That's, well, sorry to you too. Very sorry. Maybe next time we'll do a break. So ADA. Everyone knows what the ADA is. What does it stand for? Americans with Disabilities Act, right? It was passed in 1990, and it's made it illegal to do what? What can you not do? What does the ADA say you can't do? Exactly, right? Yeah, and they've actually, the Supreme Court, they ruled, there was some case, I don't remember what the case was, where they said, there's, they basically narrowed what a disability is, where it's something, basically, they said it's got to be pretty substantial, you're in a wheelchair or something like that. Well, then they amended the ADA to say that it's any impairment that substantially limits even one major life activity, even if it is even if that disability, episodic or in remission. So, so it can be, maybe we're all disabled to a certain extent. It's just, I guess, I had back spasms this weekend, so maybe so. Maybe I'm disabled. Impaired my ability to pick stuff up. So I'm gonna have to have a talk with my employer. I'm just kidding. I'm independent. I call myself. What's my number? So you can't discriminate against people who are disabled, right? And you've got to make what? What do you have to provide under the ADA? Well, she left anyway. But what do you have to provide under the ADA? Reasonable accommodations. One day I'm going to get one of you all to say something. But so reasonable accommodations. What are reasonable accommodations? So you've got to make facilities readily accessible and usable for people with disabilities. And what does that practically mean? Well, you see wheelchair ramps. Everywhere's got wheelchair ramps, right? Now, one thing the book doesn't tell you is for buildings that were built prior to 1992, there's no requirement that they have to just go slap a handicap ramp and an elevator in it. But if they undertake renovations, if you are going to, if you're going to renovate the building, and it's a commercial building or commercial space that's open to the public, then you do have to make it has to be in compliance with the ADA. Again, the book doesn't really talk about that, but you can't just, there's not an affirmative requirement. If you've got this dilapidated old building and you have no intentions of fixing it up, you got an old bookstore that barely makes any money because everybody reads crap on Kindle now. They're not going to say, listen, you got to take those profits that you're not making and put in a wheelchair ramp, unless you renovate the building, right? So now, you don't always have to make reasonable accommodations. There are certain situations where you don't have to make reasonable accommodations. What is that? What do they call that? It's a term we've already heard in a different context today. Yes, undue hardship. So, and there are 4 factors that they look at in determining whether there is an undue hardship or whether the reasonable accommodations you're seeking would impose an undue hardship on the employer. Can anybody tell me what those factors are? Anybody? The nature and cost of the accommodations. So if it's going to be super expensive or super elaborate, that could be an undue hardship on the employer. Or on the service provider. You got to remember, it doesn't just apply to, we're talking about this in the context of, employment, but it's also applies to, if you offer your services to the public, you have a store, it's the ADA is probably going to apply unless, again, you've got some old building that you're not going to make any renovations to. They're also going to look at the overall financial resources of the facility. And the number of people that are employed and the effect of the expenses on the resources and its impact on the operations. So if it's going to cost a whole bunch of money and it's going to shut down that business for a month while they install, elevators every 10 feet, that's an undue hardship, right? They're going to look at the overall financial, well, I already said that. The overall financial resources of the facility. They also look at the overall financial resources of the entity. So the actual business that owns that facility, which I really think is the same thing. I don't know why the book made that distinction. But they're also going to look at the size of the business, the number and types of locations of the facility. So if it's a place that's got a whole bunch of facilities, they got a bunch of money, listen, this ain't an undue hardship. You need to make these changes. If it's a small business, local operation, they got one location, and they've got to keep, they're making widgets or whatever, and they got to keep pumping them out if they're going to keep their doors open. That's probably going to be an undue hardship, and they're not going to have to make the reasonable accommodations. And they're also going to look at the type of the operation, its composition, its structure, and the functions of its workplace. What are they doing? And, how is it set up? If it's a place that doesn't have a lot of interaction with the public, and it involves a lot of kind of manual labor, and they can't have employees that aren't able to lift heavy objects. They just simply, the nature of their business is, listen, we go and we haul hay bales for farmers, for big cattle operations. They're not going to have to make reasonable accommodations because their business is, flinging hay bales into a barn loft, right? So that's a place where they're not going to have to make reasonable accommodations. And again, a disability under the ADA is very broad. And again, they amended that, and you'll often see legislatures, both at the state level and the federal level, will make changes to laws specifically in reaction to court decisions. So at the federal level, Supreme Court, they rule disabilities just means people that are in wheelchairs. And they're like, no, it means any impairment that substantially limits even one major life activity, even if the disability is episodic or in remission, right? And that frequently happens where they're like, we're going to change the law based on, we didn't like how the court ruled here, so we're going to change the law specifically to overturn this court decision. And that will happen. They'll say, you'll see when I do legal research on Westlaw and LexisNexis and all that, it'll say, sometimes it'll have a little red flag and it says overturned by legislation. Of course, they can also be overturned by subsequent decisions of the courts. So.
Is there an authority that would, let's say we're a business owner, we have a brick and mortar place, we're subject to these ADA requirements, and we think we have a position that's defensible. Is there somewhere that you can go, authority, regulator, or something that says you can state your case and say, for these reasons, we think we're not subject to these rules, or we meet the requirements, and you can kind of get a stamp to say you're good to go?
You're talking about kind of like a preemptive kind of idea here, where you can say, hey,
you've seen the requirements, you've made a decision, this is what I'm going to stand on. I want to see if it passes the ho-ho test or not.
I'm not aware of any. There may be, I don't know of any. Typically, the ADA it's really on, well, one, it's going to come up, you're obviously going to have building codes and things like that, where they're going to say, you put in a permit and you say, we're going to renovate this building, and they say, okay, well, you got to meet all these ridiculous building codes. And then also, I shouldn't say they are ridiculous, but you also got to be in compliance with the ADA. And they're just going to tell you that straight off the bat. Okay, what you're doing requires, you're going to have to put in a ramp, you're going to have to put an elevator over here. You got to be in compliance with the ADA. Now, in that process, it is certainly possible where you can certainly argue, hey, we should not have to put in a ramp because of, these reasons. The nature of our business is just, we're not going to have members of the public coming in, so we don't need to worry about someone being, someone in a wheelchair needing to get into our building. How often is that going to be the case? Probably not that often, particularly if you're a business that holds yourself out to the public, has customers coming in, is pretty much guaranteed that you're going to have to make it, handicapped accessible, right? But at that stage, you could make arguments there, go to the local county, building codes commission or whatever, and whatever they call them at whatever county you're in, and say, we should get a variance, or there should be an exception for our business for these reasons. But typically, so that's one area where you're going to see the ADA, where it's going to come up. You'll also see it in a lot of times it'll happen in litigation, and I worked with a lawyer who's just this, you can get real nitpicky, where like they had a ramp and he gets in there and says, oh, the ramp, it was too steep it fell by 4 inches over a 4-foot span. That's too steep. It violates the ADA. And that is, it's legitimate. You can't have, your ramps can't be too steep. But it's often going to be litigation. It's either going to be you're doing renovations and you're going to get it at that level, with the codes commissions and stuff, or it's going to be in response to litigation. And that's where you get the chance to say as a defense. But of course, that's not the preemptive strike that you're talking about there. You're back on your heels trying to say, well, no, this is why we didn't comply with the ADA. We had legitimate reasons for not doing it, and here they are. Does that answer your question?
Yeah.
Okay. So now pregnancy is not, well, let me ask you, is pregnancy, I gave the question away. It's not a disability. Pregnancy isn't a disability, but there are, if there are complications associated with it or symptoms associated with it, they can be construed as disabilities. So the book gives the example of a woman's pregnant and she gets really bad morning sickness. Not every woman's going to get bad morning sickness when they're pregnant, but some do. And she says, can I get flex hours? Can I come in at noon after I'm done throwing up? Can I do that? Does the employer have to make that accommodation? Or would that accommodation be reasonable? Yeah. Oh, yeah. It would very much depend on the job. And that's where you look at those 4 factors. It's the nature and the cost of the accommodation. What is her position? What is she doing? How important is it that she be there in the morning? And if she wants to come in at noon, is it the kind of business that, okay, we still need you working the same number of hours, but a lot of businesses, they're closing the doors at 5:30, everyone go home. We can't just have this one pregnant woman work until 8 o'clock at night. Do we have to hire an extra security guard? Is that going to cost us money to make sure that she's safe, or to keep the lights on and keep, it's going to cost us extra money in our utilities. Those are factors that they're going to look at. It's not a clear-cut answer. It's not a, yes, you have to make those accommodations. No, you don't. And that's pretty much always going to be the case with the ADA. It's very much fact specific. It's fact specific. You take it on a case-by-case basis. But that's exactly right. It's going to depend on what the circumstances are, what kind of job it is, what her position is, and whether that is in fact going to work an undue hardship on the employer. You look to those 4 factors, and you kind of have to, you make the call there. Now, what about lift restrictions for airline ticket agent? You go to check in your bags, right? And they give you of course, nobody who gets an airline ticket, you have it on your phone, right? You're already checked in. But let's say you're paying the $50 to put your bag on the plane because you got to take a bunch of stuff with you. And his doctor says, you can't lift more than 20 pounds because you threw your back out. Does the employer have to make reasonable accommodations there? Because if people are checking their luggage, it's usually going to weigh more than 20 pounds, right? If it's 20 pounds, you carry on, not pay anything. So what accommodations do they make? Do they have to? If
they want the day to go as smoothly as possible, yeah.
They would have to make the accommodations?
They don't have to, but they should.
They should. Well, what if, so airline ticket agent, basically his job's going to be, at this point, just with the way technology's progressed, is put the tag on, pick it up, throw it on the little, the little escalator thing, whatever they call it. So what is that? The job basically is move a heavy piece of luggage from here to over here. What else is his job to do? You just give them, you just say, listen, man, you're going to have to take some FMLA leave here. I don't know what to tell you, or is it something that they can make a reasonable accommodation for them? But what if that requires, we got to have an extra person there on his shift when he might be the only one there if he didn't have that lift restriction? But then, okay, we have to have 2 people there while he sits there and processes the tickets and prints out the little tag. And then the other guy slaps it, and he slaps it on. The other guy grabs the luggage and throws it on the conveyor belt. Again, very fact specific. I think in that one, the employer arguably would have some pretty good position there to say, you got to be able to move heavy pieces of luggage. Like that's the most important part of your job. Because otherwise, you know, if you're just going carry on, I don't even go to the ticket counter anymore. I just walk straight up and it's on my phone and I take carry on. Because I can travel with a toothbrush, right? But some people need to take a lot of stuff, depending on how long you're traveling. So again, there's no hard and fast answer. I would say with that one, the employer would have a better argument that it'd be an undue hardship to say, to make reasonable accommodations for that person. But I don't know, you know, again, that's going to depend on the airline. Do they have enough people that it's not going to matter? Or is it a smaller airline and, you know, they can only have one person at the counter and need them to lift heavy stuff? What about websites? So they give some interesting, like deaf people and blind people using websites. I don't know how blind people use websites. It's just, my mom's legally blind and she doesn't use websites. But so videos for the deaf, the Association for Deaf People, or the Deaf Association, sued Netflix several years ago at this point. And they said, you were violating the ADA, you were discriminating against us based on our disability, which is we can't hear anything because you got all these videos, but we don't know what's going on. We can't hear anything. All we can see is what's happening. How do we get to this point? How did this character get here? What's happening? We don't know. Well, how do you fix that? Is there a reasonable accommodation there? Yeah, subtitles or closed captioning, right? Very easy fix. Just throw in some closed captioning, problem solved. They can read what's happening. Now they know the story, the plot no longer escapes them, right? So that one, now you can, any Netflix, you know, we know the answer to that because you go on Netflix or any of the streaming services and you can hit that little closed caption button and read it out, right? So that was a case where you can't, it's not an undue hardship on Netflix or on any other streaming service to have to provide closed captioning. You know, that's, you hire somebody to just sit there and type out what they're saying. Not that big a deal. Type in explosion, you know, scary music in background, which is, that's fine. But what about websites for the blind with Target? Was it Target that got sued? I think it was Target. And the blind, it was the Association for the Blind that sued, I think, Target to say, you know, we can't use your website. It's discriminating against us who are blind and we can't see your website. Now, how do they fix that? That litigation actually dragged out for quite a long time. But what did they ultimately do? And I don't think they actually had a ruling on that one. I think it ended up working out kind of a settlement. But I could be wrong. You know, if anybody wants to correct me, please do. I won't knock your grade too much. Basically, like read out, the website just reads out the text. So they can hear, but they can't see. It's like the opposite of the Netflix, right? So they just read out what's happening. But then what do you do about Netflix? You know, they can hear what's happening, but they can't see what's happening. I don't know. But yeah, radio's better. Anyway, if y'all, I don't know, anybody Vols fans here? Okay, right answer. Bonus points. I like to watch the game, but I put the radio on because the TV announcers are just atrocious. Gary Danielson. Ugh. He's the worst. Oh my God. Alabama's so great. Shut up, Gary Danielson. Nobody cares. But yeah, they just like they read out the text. That one's a little bit different. But like, what about a library? And I don't know if this was an actual case, but they gave the example of what about a website that like Gutenberg, you know, that provides free books like the classics, you know, and you can just pull them up and read books for free. What do you do for blind people? What can they do for a website that all they do is they provide books for free for people to read, scroll through and read? What can they make reasonable accommodations?
Most of them have auto with them, do they not?
They have what?
Like auto with them.
What do you mean auto?
Like
Or audio, you mean, okay, audio. Sorry, I thought you said auto.
No.
It's the mask. Yeah, so like, but what would that be, you know, like a robot that reads out the text? Boy, that would get old fast, especially if it's a long book, you know? I couldn't imagine that. But you've got Audible, but that's different. You got to pay for that. And then you actually, that's someone actually sitting down and reading the book, right? And that would be an undue hardship for if it's a little library website that it's not like they're making money off what they're doing. Well, they can't afford to pay some voice actor to read out every one of the books. Now, could they do the that reads out the text for you, sort of like Target does with their website? Yeah, but how expensive is that technology? And again, we're dealing with a website that goes back to what are the resources of this employer, this service provider, this website in this case. No, they're probably not going to have the resources. Even for that might be too expensive for them. And again, you're talking about books. It's one thing to have it read out, Lamp at Target, $59 versus, you're reading War and Peace and it's a robot reading it out to you. You probably go crazy. So that's one. That book doesn't really give us an answer there. I give it that a question. I would say my argument would be that's an undue hardship on a website like that, because again, it's not like they're making a bunch of money. They don't have a lot of resources. And how practical is it to have the robots reading out the books? I would say not very. So, but again, there are plenty of judges have disagreed with me before. I don't like those judges, but it happens. Courts could rule, hey, this website, they need to, if you want to provide this to everybody, you can't discriminate against blind people. You need to have the robot reading out the voices. Maybe. But that's one that probably they're going to say that's an undue hardship. So we'll circle back around. I'm on the last page of my notes here. We're almost done. Equal protection. So the Lozano versus City of Hazleton. Hazleton's like a coal mining community in Pennsylvania, probably Western Pennsylvania. And they had a lot of immigrants apparently moved there after 9/11. So in the aftermath of 9/11, there were a lot of immigrants in New York City and the surrounding areas that experienced a lot of discrimination from, people got real jingoistic or xenophobic or whatever you want to say, patriotic, however you want to describe it, in the aftermath of 9/11. And so there apparently were a lot of immigrants that, and there was also a crackdown on, there was concerns about immigration, concerns about, hey, we need to know who is here. We've got illegal immigrants that are here. So there was implications there with finding terrorists, things like that. So a lot of immigrants moved to this city, to Hazleton. They had a population of like 23,000 in 2002. By 2005, the population is like 33 or 35,000. So a huge influx of immigrants. And eventually, it was causing it. They argued it was causing a lot of problems. And they said, hey, we're having an increase in crime. We need to do something to handle this situation. So they passed an ordinance that made it unlawful to employ or rent to illegal aliens. And they termed it illegal aliens. And that was it. They said you can't employ or rent to illegal aliens, period. They didn't say illegal aliens of this particular race or anything like that. So no mention of or reference to race, nationality, or ethnic origin. How did the court, and it came before the court, Lozano versus City of Hazleton, how did the court rule in that case? And the court's looking specifically at whether this ordinance that said you can't employ or rent to illegal aliens, the court was asked to look at, does this violate the Equal Protection Clause of the 14th Amendment? Shaking your head. Yeah, they said it's not constitutional. Now, why? Why did the court say this isn't constitutional? They said, well, okay, they said it wasn't constitutional. Let me back up. What test did the court apply? Which one of the, what level of review did the court give to this ordinance?
They used strict because they said it would exacerbate defensive hiring. So like do it make people more likely to avoid hiring people who could be illegal aliens? So they said like it would discourage people from hiring like foreign or immigrants.
Now, is that what the court ruled there?
You see the Supreme Court, because the lower.
No, I'm talking about the lower court. Yeah, okay, yeah. Let's talk about the lower court
Okay.
first.
The lower court said they supported the the act.
Yeah,
The lower-
the lower court applied rational basis.
Correct.
And the reason they did that was they said, okay, it says illegal alien, no mention of race, no mention of nationality or anything like that. So this doesn't have, there's no, suspect classification here. We're not implicated in a protected group. But ultimately, it was overturned. That law was overturned, even though the lower court said rational basis review, this isn't discriminatory, there's no violation of the equal protection law or equal protection clause here, but it was overturned because it was preempted by federal immigration law. They said, you can't make this law that says, okay, here's how we're going to deal with immigration when you're a city. And even arguing states have more leeway with that, but cities, that's always going to get, hey, federal law preempts that. Federal law addresses immigration, how immigrants, or illegal immigrants, I should say, get treated. So they ended up saying this is preempted by federal immigration law. Now, I must have missed in the reading that this went to the Supreme Court ultimately, and they did apply strict scrutiny to that.
I think I might have just misread the district.
The only thing I saw was that it did not apply strict scrutiny.
Okay.
in the District court, I don't know.
Correct.
Okay.
The ACLU got involved. and stuff.
I'm reading what the plaintiff said, like.
Yeah. Okay. Yeah. See, and you do have to be careful, and that's one of the many things about legal reading that can just, your eyes start rolling back in your head, and before you get to the end of that's why it's helpful to read the end of an opinion first. Okay, here's how the court ruled. And then it helps you clear, okay, this is what the plaintiff is saying. Strict scrutiny should apply because illegal alien is necessarily going to implicate to people or indicate to people, oh, we're talking about people that are likely of, Central American or South American descent. But that's not necessarily always the case. You can immigrate illegally from all over if you get to Mexico first. Or people fly over and then just overstay their visas, and that's technically you're an illegal immigrant at that point. But so the book asks us, and I'll ask you: should illegal immigrants, people who are here in violation of immigration laws, be protected by whistleblower, civil rights, and workers' compensation laws? Now, I'm not asking are they, should they?
It depends on how you're brought here, like if you, it sounds like you came here, you're the parent and came here and brought your kids that are not even 2 or 3 years old yet, then those kids should have the same rights as the parents.
So you're looking at it from kind of the dreamer's viewpoint, sort of. It's like, hey, it wasn't their decision to make, and they're here through no fault of their own, and they shouldn't be punished. Is that kind of what you're saying? Okay, and I think that's a fair view to take on it. I will tell you that workers' compensation laws, at least in Tennessee, they're not going to make any distinction. If you're here illegally, there are punishments for the employer, but they're not going to punish the employee. So if someone is here illegally, that's saying often it'll be in construction. Agriculture is kind of a separate thing; it's its own world. But construction, there are a lot of people here illegally working construction. I did construction work between high school and college. Worked with some great people. I guarantee you that at least 90% of them were here illegally. But if one of them was injured on the job, they would get workers' compensation benefits for their injuries. They would not be limited to, and they tried to pass a law that did limit illegal immigrants, the benefits they could get for workers' compensation, but that was overruled. They said it's unconstitutional, and there are good reasons for doing that. Now, illegal immigrants can't get Social Security benefits. There are a lot of things that they can't that they can't get. But in terms of workers' compensation, what?
Is that illegal immigrants do get workers'
Yes,
compensation?
they will get where they do get workers' compensation. And again, workers' compensation is it's not some sort of cash grab scheme. You know, it's not like a personal injury case or something where you can just get all kinds of money. It's a mathematical formula. You're set. What's the percentage of your disability to your body as a whole multiplied by, you know, your comp rate, which is 2/3 of your average weekly wage, you know, and multiplied by a set number of weeks, and that's your number, you know, and that's the same whether you're an illegal immigrant, whether you're native born citizen, a legal immigrant, a legal immigrant, doesn't matter, right?
Legal immigrant and
Yeah.
all that, but
Why should illegal immigrants?
Yeah.
Yeah. And there's, you know, in context of workers' compensation, you know, it's really kind of it comes down to a fairness argument. And, you know, Tennessee did try to make it so that illegal immigrants could only get a lower level of workers' compensation benefits. But again, it's not, one of the big reasons, they won't say this, but you know that one of the big reasons is it makes sure that hospitals get reimbursed for medical treatment they provide to the illegal immigrants that they would otherwise not get. You know, they would go and they get the treatment for the injury and then they're gone, never see them again. The workers' compensation scheme ensures that the insurance companies have to pay the hospitals at these significantly reduced insurance rates.
And the employer
reimbursement.
pays as well, and the employer pays into that as well.
Yeah, now yes, the employer is supposed to maintain workers' compensation insurance. You pay your premiums, and your premiums might go up, but you're not going to be out of pocket, you know, tens of thousands of dollars.
Follow the worker, yeah, I get the worker, the employer has to pay in.
Right.
If you want to fine them or do whatever, you know.
Yeah, and again,
So what
that's,
happens if an illegal immigrant files a workers' comp claim and starts getting their workers' comp, but they, you know, to file this would become known, you would think they're an illegal immigrant, right?
yeah, and that
Yeah,
will,
that-
yeah, and that will, a lot of them won't do it specifically because of that. They don't want their name to be associated, or and I used to do workers' comp defense. We would we'd give it a different name at every hospital. They go to one hospital and say their name was X, and they'd go to the next hospital is Y, and the next hospital is Z, and they try to say these are all the same person, and you're like, well, how do I know that? But usually they'll just take, you know, whatever settlement they can get, move on. But yeah, they still won't do it for that very reason. But the state has said, as a matter of public policy, but also as a matter of constitutional law, we're not going to deny workers' compensation benefits specifically to illegal immigrants. Now, it's not carte blanche. They get every benefit that legal immigrants or, you know, natural born citizens get. But in the context of workers' comp, they are going to get those benefits. And it's a definitely debate. It's one the state had for a long time. It's one the General Assembly here didn't want illegal immigrants to get the same level of workers' compensation benefits, but they say, hey, Constitution says you have to. So in that situation. But again, that's and that's why I asked, should they get it? So Austin, it sounds like you'd say, well, I don't think so. Yeah, so whistleblower.
Whistleblower, things like that, find the employer, take action with the company.
Yeah, and that's the big question. You know, you get people that are, you know, opposed to illegal immigration or to the rate of illegal immigration, and they say, well, let's punish the illegal immigrant, make it so they don't want to come here. It didn't really get to the root of the problem, which is employers. If they're still hiring the illegal immigrants, then people are still going to immigrate here illegally. So you go after the employer, you find the employer, and you say you're going to get punished for cutting corners because why are they hiring the illegal immigrants? Because they'll work for cheaper. They don't have to pay insurance on them. You know, they don't have to file paperwork on them. They can just pay them cash and move, and that's all they have to do. They can say they have fewer employees than they actually do. When you start going after the employer, that's going to stop. You know, they're not going to have that access to that better job market, right? by coming here illegally. They'll say, well, I'll come legally so I'll still get better job here than I would at home, but not if I do come over illegally. Now will that actually happen? Well, one, you got these employers, big farms and stuff. Now they like the illegal immigration, but that's a huge debate. We don't need to have all of that right now. And I know you all want to leave really badly. Well, we've only got about an hour and 20 minutes left, guys, all right? And then civil rights, civil rights. So we look at the 14th Amendment itself, what does it say? Specific, of course, I'm not gonna be able to quote it exactly to you, but it says no citizen or person, born in this country or naturalized, they're all entitled to equal protection, right? You can't treat them differently. How does that really address? That didn't really address illegal immigrants, right? So that they don't really fall within that class of people. So should they be entitled to the same civil rights we all enjoy? That's a debate that's raging now and will continue to rage until Congress decides to finally do something about it. Maybe they should enjoy some civil rights, but not the full panoply of them. Maybe they should enjoy all of them. I don't think anybody's really going to argue they shouldn't have any rights whatsoever, because, they're human beings, right? But if they're not going to respect the immigration laws, people argue, well, what other laws are they going to respect? And that's a tough debate. But what about deportation? Ethics of deportation. Is deportation ethical? Deportation, obviously, of illegal immigrants here, what we're talking about. What would the utilitarian approach to deportation be? Would they say, yes, that is ethical, or no, it is not?
Deporting illegal aliens makes the general populace safer or happier, then yes, deportation would be ethical.
Yeah, so it's, and again, I'm not saying with these kind of questions, there's not necessarily, this is the right answer, this is the wrong answer. But I think that is a very plausible argument from the utilitarian approach is we can harm some illegal immigrants in this case, which is anywhere from 11 to 20 million people, for the greater good of the 330 million people that are here legally or were born here. And you say, hey, we deport the illegal immigrants. That's more jobs for the people who are here legally or are born here. There's more money to go around from insurance premiums are lower, those kind of arguments. Yeah, utilitarian approach. There's a very good argument that, okay, deportation of illegal immigrants is ethical. What about the deontological approach or universal principles? Well, again, you're getting into your question of what are universal principles, and we're not philosophers here. I don't know what is a universal principle. It's what is right, no matter what. Did Kant? Did he care about taxes? I don't know. I hope not. But I guess it depends on what is what's the absolute truth or the universal principle here is we treat all people equally. If that's the Kantian view you take, then there'd be a good argument that no, deportation of illegal immigrants is not ethical. But if the universal principle you take is all people must obey all laws, then you'd say, well, then it's certainly ethical under the deontological approach to deport illegal immigrants. But then you're looking at universal truths. Are all laws just? No. You can say no. I think you can just say no, not all laws are just. We don't have to get into which ones aren't just, but we might disagree which ones are just, but I think we can all agree there are some laws that just aren't just. Virtue ethics. What is that? If that really, and again, virtue ethics is so old, and it's a hard one to apply. Would they say Is it virtuous to deport illegal immigrants? Well, I guess it depends on which side of that argument you're looking at it from. You know, it's virtuous to follow the laws of the land versus it's virtuous to, you know, care for all people in society. That's a tough one. You can make arguments either way. Of course, I've made arguments either way on every single one of them so far. So, which is right? None of it's right. It's all right. It's all wrong. It's all right. Free market ethics. What would free market ethics say? Now, I think there's a right answer on this one. Oh, man, cheap labor. You kidding me? Bottom line, let's open those borders up, take those walls down, and let's get some cheap labor in here, right? So free market ethics would probably say, no, we don't need to deport anybody because it benefits corporations, right? It benefits shareholders of and it depends on the corporation, right? So if you've got a big corporate farm having a source of cheap labor that it costs them less money to get their produce, you know, harvested into market, they're going to say, no, keep them. You know, it's the bottom line is what matters. And then the ethics of care, you know, we're all one big happy family. They're going to say, probably don't deport, right? They're going to say, we have to care for all people. It doesn't matter whether they're here illegally or not. They're still people, and we need to care for them. And deporting them is not caring for them, you know? So the two newer schools of thought, even though they are on extreme opposite ends of the spectrum, are both probably going to agree, hey, we don't need to deport 11 million to 20 million people from this country. That's crazy. You've got a little bit more, you know, you can make arguments either way. Probably the utilitarian's going to be in favor of deportation. Deontological, I don't know, virtue ethics, who knows? And then Austin, you brought up the University of Texas case, and we'll finish with this, talking about affirmative action. Yeah, we'll finish with this. So talking about affirmative action, which we all know, do we all know what affirmative action is? Yeah. I mean, so the idea is, okay, we are technically going to discriminate on the basis of race, but do so in a manner that is correcting historical inequities that hurt people of this particular race. We're going to give them favorable treatment to try to balance the scales back out, right? And that was an idea. It started coming out, I think, the 50s, and by the 70s, it was really in full swing. And then University of Texas, you know, girl, what was her? I don't remember her name, but she sued the University of Texas. She was a white girl, and she sued the University of Texas and said, I was denied admission to the University of Texas because I was white and I didn't meet their diversity quota. And she argued that that was discrimination on the basis of race in violation of Title VII, right? And they had two plans. So the University of Texas had looked at it and they were trying to do, she said, well, they could have done more community outreach, you know, to try to, because the University of Texas wanted to boost the number of the diversity of their student body. They said, look, there are educational benefits to having a diverse student body. We need to have a diverse student body, and it's simply not diverse enough right now. So we've instituted this plan where we are going to look at race as a factor in student applications in determining whether we're going to admit these students or not, right? And she says, that's racist. You can't do that. Why are you doing that? Because I'm white. It's because I'm white, isn't it? And in a way, yeah, it was. But, you know, they said there's educational benefits that flow from having a diverse student body. And so therefore, and this was actually a case where it survived strict scrutiny, wasn't it? So they looked at it and they said, yeah, that's protected. You've got a suspect classification. You've got an admissions policy that is specifically based on race in part. But they found that it was narrowly tailored to serve a compelling government interest, because University of Texas is a government, you know, it's a public university. So it's considered a governmental entity, compelling government interest. And then there was no less restrictive alternative. You know, Texas came in and they said, listen, we tried to reach out to minority communities. It only boosted our numbers a little bit. They had their top 10% plan that said, the top 10% from any high school, of the student body in terms of grades from any high school in Texas, or it might have been nationwide. You'll get admitted based under that. And the plaintiff in that case, she argued, well, you should have let everybody in under the top 10%. Of course, she wasn't in the top 10% of her class, so I don't know why she made that argument, because it'd been like, okay, well, then you still don't get in. But she said, why don't you do just the top 10%? That wouldn't be racist, Well, the courts say, the majority says, and we talked earlier about kind of the disparate experiences or upbringing that people have in different communities, that, particularly for Black communities, they didn't have the same opportunities. And so they often wouldn't score as well on standardized tests, or they might not finish in the top 10%. You still would have a skewed, in terms of racial makeup, it'd still be skewed towards certain races and not towards others. So they said just a 10% plan, top 10% plan is not good enough. So the majority judge say you can have a race-based admission policy that survives strict scrutiny. Even though it's race-based, there's a compelling government interest in having a diverse student body. Now, there is, or at the time, there was one Black member of the United States Supreme Court. Was he with the majority, or did he file a dissenting opinion in the Texas case? Yeah, Justice Thomas. He filed a blistering dissent. He was actually pretty, and if anyone recalls, I guess we're all too young to recall, when he was appointed to be a Supreme Court nominee, it came up again in the news. But he essentially, he was nominated by President H.W. Bush. Bush won, Bush the first, right? And they went aggressively, the Democrats went aggressively after him in his confirmation hearing, which that had really started in the 80s, where they really started getting very partisan in the confirmation hearings for Supreme Court justices, which is unfortunate. But he said, Justice Thomas, he said, this is nothing more than a high-tech lynching, against a Black man who dares to, deigns to think for himself, or to deviate from what should be how Black people should think, right? So he's probably a little bitter still, and that kind of came through in his dissent here. But he said, making race relevant to the provision of burdens or benefits is demeaning. It demeans us all. And he said it doesn't matter if there's a faddish theory that racial discrimination may produce educational benefits. He basically said, if you're bringing race into it, period, that violates Title VII. He says you shouldn't bring race into it at all. Everyone should be looked at, on the merits of their own character. Oh man, can y'all still hear me over there?
Yeah.
Yes. No.
Yes.
Anybody hear me? Check. Okay, I think it's back on. But basically, he says his dissent is, if you bring race into it at all, first off, that's demeaning all of us by saying that, the whole point of Title VII is we're taking race out of the equation. People can be their sex, their gender, their race, their national origin. None of that matters, and it matters a great deal, but it's not going to come into our decision-making process for the government. We're not going to make decisions based on those immutable characteristics. But the majority says, no, you know what? Diversity is good. Diversity in education in particular is good. So we're going to allow this survives strict scrutiny. Who agrees with the majority opinion in that case? And this is not, whatever your opinion is fine. I don't care. Does anyone think the majority got it right? You think the majority got it right? You all think the majority got it right over there? Yeah. Anybody think that Justice Thomas is right, that race should just not factor into the decision-making process at all? No? Yes? Okay, I got one. Okay. The voting is really falling apart here. So that's, are there any right answers here? You'll find that a lot in this class, with both law and with ethics, that there's no hard, fast, this is what it's right, this is what it's wrong. Sometimes there is, but a lot of times it depends, right? Any good law professor, you ask them a question about anything, and the answer is always, It depends. So, that was a case where the majority says, we can look at race. This is an exception to Title VII where we can discriminate on the basis of race because we got a compelling government interest, a good reason for doing so. So that's the 1 out of 10 where strict scrutiny, where a law survives strict scrutiny, or a policy, not really a law. So does anybody have any questions about the Equal Protection Clause, Title VII, and diversity in the workplace? No? Anybody have any questions about case briefs? Oh, no, tons of questions. Yes.
For when you're citing the dissenting opinion, you're supposed to do the short one and then page number and then comma dissenting.
Yes. So you don't I cleared it off. So the first case cite, you do that, the full name, and again, not every single party, but the first 2 main parties spelled out completely, 590 US at blank parentheses, the year. And then after that, you do your short form cite. So with the first one, it would be Maine Community Health, comma, 590 at page number for the majority opinion, period. That's it. For the dissenting opinion, and remember those page numbers, count over, start over, read the one the page number that's actually on the opinion, not the one that's up on the counter for your PDF. And you would do, Maine Community Health, comma, 590 at 2, in parentheses, Alito, comma, J, comma, dissenting, in parentheses. And that's with the dissenting. I did say in the last class that, you do that once and then you can go on and just do it regular from there. Let's not do that. If you're citing a dissenting opinion, and the same for a concurring opinion, do that parenthetical after the page number cite. Say, whoever the dissenting justice is, comma, J, comma, dissenting, or concurring, whatever the case may be. You don't need to do that for the majority opinion because that's the opinion of the court, but you do need to do that for concurring opinions and for dissenting opinions. And remember, if there are multiple dissenting opinions, that you make it clear this is Alito's dissenting opinion or this is Thomas's dissenting opinion.
What if I want to use facts from the dissenting opinion and a different part of my essay?
You can do that. If you're in the main part of it and you say the majority, they ruled that, that insurance companies can sue the government under the Tucker Act. The government needs to honor its obligations, do the regular cite, and then say, in contrast, Alito argued that, the court should not be creating causes of action without express authority from Congress, cite, but make sure you cite to do that dissenting cite. And as long as you have that dissenting, Alito J dissenting, and the correct page number for the dissenting opinion, it doesn't matter where it is. Now, usually it's just going to be in the reasoning of the dissent because you're talking about the dissent in that section, right? But if you want to talk about it in a different section, that's totally fine. Just make sure you do the citation correctly. All right. Any other questions about case briefs or the reading? Okay, we're done.